Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
This police unit is trying to box him in, but instead he just crashes into the tree, and away he goes. But let me widen out. I don't know how far this will take him. Yeah, he's basically cornered. Wow, look at this. Off the road and onto the freeway. Oh my gosh, so he is on the freeway, going wrong side of the road here on the 91 freeway, going eastbound in the westbound lane.
Oh my goodness, even without the video, I love the audio from a police chase. Good morning, welcome to Thursday morning here. I feel a little bit crooked. Is it crooked? We'll make it work. Is that better, worse? I'm not sure which. Good morning, everybody. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for being here. Happy Thursday, or as we say around here, Friday Eve. Friday Eve is here already. Welcome. Hope you have some plans for the weekend. Okay. Oh my goodness. We have some fun stuff today. We have some things to talk about. We have a couple small courts that we expect some fireworks in, or some interesting cases. So we're going to keep our eye on that. Some of that's starting pretty early this morning. Oh, good things all around. Good things all around. Let's see, you're taking a page out of Michigan Court Reporter Cameron's book by not having the right camera. Yeah, a crooked camera. Crooked camera for the win. That's what I'm going for here. Oh my goodness. Let's see. Before Michelle, first of all, that's awesome. I'll put this on the screen. That's awesome. Spending the day with my new grandbaby on Saturday. There's very few things that beat that as far as what you can do. Just one second. We have to first celebrate one particular person while I'm busy making notes at the same time. Hang on one second. Get this one. Okay. Got it. Okay. First of all, welcome. Congratulations to Dudley Lucky. Dudley Lucky. You may not know. It might have been a completely innocent mistake on your part, but you committed a major offense this morning by breaking the silence of the morning on the show and being the first person to talk in chat. That is a punishment that cannot go unpunished, or that is an offense that cannot go unpunished. And because of that, we are going to sentence you to internet ownership to punish you for your crime. We are now going to award you internet ownership, sentence you with internet ownership. And what that means for you, Dudley, is that in addition to whatever else you had going on today, however full your schedule was, whatever pressing engagements you had set up, you are now responsible to do one more thing, and that is just to maintain everything IP related worldwide. That means if it plugs into the internet, if it connects to your Wi-Fi router, if it connects to your neighbor's Wi-Fi router, if it connects to your school's Wi-Fi router, or your businesses, or anyone else's, you're now responsible for maintaining it. It's a small thing. What will basically happen is all the phone calls from everybody who has a problem, they'll be calling you. It's a little thing that we can do here, just awarding the internet as a punishment. And now, congratulations, that's you. This will go on your permanent record. If you would like to make a physical record of this offense, you can go on our merch page, and for the low fee of 50 cents, you can print out your record in the form of a certificate claiming that you have indeed won the internet. Congratulations, Dudley. Thanks for being first in chat. That being said, we have some birthdays. I know there's some birthdays. And I've got two of them already, so hopefully, let's see if there are any others. Oh, let's see. Lori, is that Coffee and Crime? I think Lori has a birthday as well. Let's see if we have any birthday lists. We'll go ahead and sing to them. Let's see. Sad news, Babs. Thank you. A couple people reached out to me and even sent me a copy of the notice. I believe the obituary notice or the funeral thing, that Paula, the witness from the Treehouse murder trial, the one who's in the hospital, who testified from the hospital, that she passed away. and that is sad news indeed. Let's see. Can somebody? Can one of the mods? I love this. Can one of the mods please rebel 6 volt? No, just flat out rebellion right there. Thank you, Samantha. Thank you, 6 volt as well. We have a buffer sound. Let me. Actually, the sounds are way turned down. They're way too quiet. My kids have been playing Minecraft again. Okay, there we go. The sounds are back up for a little bit. Where were we? There was a buffer sound. There it is. So we have Josh, Owen, Groovy Jill, Debbie.
I'm not a camel.
Debbie, Percival, and I believe Lori as well. So Josh, by the way, Josh is 22 years young, and that is BG's baby boy. Congratulations. Happy birthday, Josh. Let's see. Owen. Let's get Owen on the list here. Groovy Jill. Helps if I spell it right. I'm adding extra letters to your name. Groovy Jill and Debbie. Okay, I've got... So actually what I have...
I was kick back, taking it easy.
I have Josh, Debbie, Percival.
Somebody just sent me a video of roaches fighting.
Yeah?
I don't know who won.
No.
Have them send someone with more experience.
We've got Josh, Debbie, Lori, Owen, and Groovy Jill. That's who we've got for the, as far as...
When are we going to break for lunch?
When are we going to break for lunch? As far as the birthday song this morning, we're going to go ahead and sing to them. Hopefully I'm not missing anyone else. If I do, please know it's not intentional.
Are we going to address subject matter jurisdiction?
Nancy, I just in time. You just barely, right as we were about to hit the birthday song. Nancy will add you as well. Remember, this is not just me. The Broken Baker gave you a shout. Broken Baker, I love the show. I love how he always has like a panel of people to discuss things. That's impressive, being able to organize it like that. Let's see. Also, Ron's birthday. We need Ron on here as well. Hubby of Buzzy Bee Cottages. All right. Let's see who else is there. Internet owner got a membership. Hey, it pays to be first in chat. That's what I can say. It looks like that was that given by OG Sean White. Thank you very much. Let's see. Do we have any other birthdays? Last call. Last call. Nancy, we got Nancy. Okay, so Josh, Debbie, Lori, Owen, Groovy Jill, Nancy, and Ron. Let's go ahead and sing. This is not just me singing. This is everyone singing. Worldwide, we're going to blend our voices in joy and celebration. La 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 la. We're all warmed up. Remember your parts, guys. Shoulders back. Blend your voices. Project to the back of the room. Happy birthday to you. Happy birthday to you. Happy birthday, Josh, Debbie, Lori, Owen, Groovy Jill, Nancy, and Ron. Happy birthday to you. Josh, Debbie, Lori, Owen, Groovy Jill, Nancy, and Ron. There, I got the names right at least, even though it wasn't during the song. Happy birthday to all those who are celebrating their birthday today. We realize there are many places, that you can celebrate your birthday. But here you are with us today. Happy birthday. Thank you very much. I hope we can make your special day just a little bit better. Make sure you help yourself to the free pancakes. This song lives permanently in my head every day. I love it, Paul. It's always someone's birthday. That is what is wonderful. Somewhere, I mean, we oftentimes we can. Let's get serious for a minute. Do we have any serious music that I can? I think I've got. I can do this one. It's easy in life to reflect on the things that happen to us, the conditions, the cards we were dealt, to maybe compare ourselves to others who might seem to have a better hand, often that through like no effort of their own, and we've been trying, we're working, and it's easy to see that sometimes things just aren't fair, and no matter how hard we try, we seem to lose over and over, and it can get to be a habit to look at our life and see all the bad things that are happening. But amidst all of that, if you just stop every morning and think that somewhere out there in the world, someone is waking up and it is their birthday and they are excited. they have a smile on their face, and there's an expectation that there might be somebody who they haven't talked to in a long time who remembers them and wishes them a happy birthday. That makes me happy. And what makes me even happier is that I get to wish you happy birthday. So to all those that are celebrating a birthday today, thank you very much. There's the sad music. There's the sad music. That's the only one I had to talk to. I'll need some more music to go under that as well. New music beds on order. Haley's comment, whoop, whoop, 8 months, woo. That's awesome. My nephew Dan turns 1 today, says Francisca. Happy birthday, Dan. That is awesome. Jared Wonder, happy birthday to Jared Wonder. Or Jaded Wonder, excuse me. I added an R there.
Don't miss the forest for the trees.
Don't miss the forest for the trees. That's a great line. OG Sean White, thanks for gifting the membership. Says, we made 5 months. Glad to be part of this family. We also have, Haley's comment made it 8 months. And Sean White gifted a membership. I think that went to the internet owner. I have to be careful how I say that. BG gifted a membership as well. Thank you, BG. All right, we have wonderful things going on here. Let's see. We have a case that should be coming up here in just moments. So I'll watch for that. Let me first give you our update. We believe, our fingers crossed, we believe we're going to have a case that starts Monday. And it's going to be a several week long case, and it's not the Ayden Montgomery. I realize a lot of people are asking about Ayden Montgomery. I realize opening statements are that today. The jury view was yesterday. We have great channel members who are in the courtroom in that trial. And I'm excited for them. I really am. I know that the details of the case, just from what we know from last time we followed Ayden Montgomery in trial, where he had the firearm charges, and from reviewing this case that involves Harmony, it's terrible. It is heavy. There will be twists and turns. I know this morning, I think he's going to plead guilty to some charges, but not the others. So it's like last minute guilty plea. It's going to be spicy. It's going to be fiery, but it's going to be heart-wrenchingly sad as well. And because we just went through a pretty difficult case that involved a school shooter and kids losing their life and being injured, and teachers, we're opting to skip that one. And I do apologize. I know a lot of you say I really want to watch that, and it's not the same anywhere else. I am sorry. I really am. But I think that we'll have some great material that you'll like to watch here as we follow these other cases, because we have a case coming up that is perfect for anyone who ever has wanted to throw their foam gavel at the TV when the judge makes a bad ruling, or has been frustrated at the fact that sometimes the courts doesn't appear to be doing what is right. Because the case that we are going to try to pick up on Monday, with fingers crossed, I mean, it still might fall apart at the last minute, but the case we're trying to pick up on Monday is a judge as the defendant. And it is crazy. It is crazy. And we'll be watching basically through the evidence that's presented in this trial, the impact that a bad judge was having on a trial. And when I say bad judge, that's allegedly, because obviously everyone is innocent until proven guilty, or unless proven guilty. So that is what I'm super excited for. We've got our fingers crossed. We've done a little bit of homework there. I've got some great help from some amazing people that have helped try to put this together for us. So we think we're set to go on that. That starts on Monday, and it's going to be crazy. It's 300 witnesses are on the witness list, and we've seen trials like that before where they had that many witnesses. Of course, they're not going to call them all, but it's going to be spicy. It's going to be wild. It's going to be, your jaw will hit the floor. It's going to have attitude through the roof. It's going to be good. It's going to be really good. All right. So yes, we're going to try to do the texting judge, and hopefully you love that here. All right. Cross your fingers, toes, and eyes, says Melanie. All right. I was skipping chat just for a minute, so I do apologize. Let's see. That is. Let's see. Where are we? Ayden Montgomery is going to plead to charges so he doesn't have to take blame for the actual crime. He does appear to be trying to weasel his way out of that. So I understand, Ashley, I understand. There are several of you who really, really want to watch the Ayden Montgomery trial, and I do not blame you. If you do, I hope you find a place where you're able to watch it and enjoy the community as well. There are some wonderful communities out there. Some of them are different. Some of them are more spicy. Some of them have vocabulary that delves into areas that we don't on this channel, at least not intentionally. But there are some great places to watch. There's some great creators. If you find a good one, I hope you enjoy it, and then I hope you come back too. So, all right, let's see. We have let's see. Where are we at? We have court that's starting here in just a minute, right here, and I want to see if we can bring in a feed, because I have heard that our good friend, our good Judge Cedric, has a very, very interesting case coming up this morning that might involve a stolen police car. A stolen police car, and we don't always have those. EDB has covered the texting judge as well. I tell you, the texting judge issue, we love it. It's crazy, but do you know who loves it more than we do? Lawyers. Lawyers love that case. So we're excited to have some great lawyers out there that can give us some context and information on that one. Grizzlies are watching it. That's wonderful. Okay, let's see. Just got my kids calling the cat outside. Just got an update on. Looks like Courtney Clenny's parents just turned themselves in. I think that might have happened last night or this morning. Courtney Clenny, for those that don't know, she's the OnlyFans model, and her parents are now charged with evidence tampering, I believe, are the charges. So that's exciting. There's another trial we're not going to watch for obvious reasons. Let's see. Icked and Melanie Little are covering the Adam Montgomery trial. Those are two places you can watch it. I know we sent a bunch of you over to Melanie yesterday. She was reading through some of the documents because the case sort of had a weird opening. I've never seen the jury field trip happen day one before opening statements. I've never seen a court, send somebody out there to go look at something and them not know anything. It's like, why am I at a pizza shop? We're just supposed to walk around and look at the pizza store. All right, now what? And then they're going to find out that they were walking through a scene where a body was concealed. So it's going to be crazy. All right, Grizzly's covering on a 3-hour delay to defluff and breaks and such. That's a great idea. Grizzly does a great job there. Today we're going to watch some smaller courts. We have a document I want to cover. If you follow me on Twitter, I tweeted this out yesterday, and it's got me frustrated. And I honestly want to bring something to your attention. It's a filing from a court that I really, really, really disagree with. And I'd like to get your feedback, and not just that. I wonder if there's something what we should do about it, we as a community, or if there is something we should do about it. Let's see. I'm intrigued. I'm also intrigued. I got audio from the court that we're going to jump to in just a minute. So as soon as there's audio, we're going to jump to that. Running to Twitter to follow you, says Paula. I'm almost up to 6,000 subscribers on Twitter. I've never really pushed my Twitter channel. I know. So I tweet on and off. I guess it's X now. I X on and off. It doesn't sound the same when you say that. Can they still be tweets on X? But anyway, here's what I do. Without the politics of all the social media platforms, because it seems that everyone has one, that platform for me, I found to be the most effective way to reach government PIOs, which is a public information officer. I've never found another platform that is so effective at quickly disseminating information from a crime scene. That's it. I still call it Twitter. Yep. X will always be Twitter. You search Twitter on the App Store and it brings that up. So I'm just saying, with the App Store wouldn't lead us astray. Anyway, so I love it for that. I realize it has a bunch of other stuff, but for me, I have an account where I strictly follow public information officers. I'm on links and lists on some of the other accounts because I manage about 7 accounts over there that all do different things. But I'm on links and lists that if there's breaking news from a attorneys from like the district attorneys from different cities that we've followed crimes in the past and
Don't
events.
miss the forest for the trees.
It's amazing. I have not found another way to get that information. All right, let's see. Yes, I do have the info on the info part of the stream. I think it's also on the contact or the about page as well. All I'm saying is when I look up X videos, all this weird stuff comes up. Says Carmen does stuff. Carmen, yes. Let me teach you what not to Google. But that's good. All right, we have. Let's see. We're waiting.
I'm not a camel.
Where's camera 6? I need 6.
I'm not a cat.
Somebody just sent me a video of roaches fighting.
I don't know who won.
Scratch all that. Oh, that was terrible. I apologize.
Okay. My computer does not want to pull up YouTube, but that's okay. The iPad just needs to warm up, I think. All right.
Have them send someone with more experience.
Don't Google flashing when looking for roofing materials. I made that mistake. Flashing. I used to sell roofing materials, Greeners, so I know what you're talking about. I used to sell all sorts of metal building components. And yes, flashing is a roofing word. And no, don't Google it.
When are we going to break for lunch, Judge?
All right, we're waiting. I see a Zoom that's very still. Come on, where are we at here? It's just nobody's moving worth anything. Let's see what this one looks like. Yep, they're blinking, so they're alive. I thought they were frozen. I'm not sure what this bottom view is. Look at this. What is that room with the yellow coats? Is he in like a lab? I see a lot of squirt bottles. I see a filing cabinet. Is this like live from the crime scene? That chair looks anything but comfortable.
Because he's the guy.
It looks like a one of those stackable plastic chairs that are not designed to hold weight or be comfortable. But then you've got these yellow ponchos there in the background and the glass wall looking into the lab. Lots of papers on the wall. I'm curious. I need to know what this is about. Who's Curtis Smith and why are we seeing this?
Somebody just sent me a video of roaches fighting.
Why does he have the good chair like tucked up away over by the wall and he sits on the bad one? This has got to be the strangest feed ever. I mean, the beard game is on point. I see that, and I see a ceiling fan as well. So Dennis knows what he's doing here, but the rest of us have no clue. So we'll watch this. Court's going to start in just a minute, and it might be spicy this morning. Lab coats are white, not yellow. So they're like raincoats, but see the one on the right in the bottom in the corner by the milk crate. That one looks so long, it looks like they're probably a pantsuit part as well. Car wash, maybe?
Someone has their thing off of mute. If you could mute it, please.
Oh, you want me to mute?
Oh, I thought it was me. Oh, man. I thought it was me. If you search Henry Barokel, Bexar County, you can find the story about the guy impersonating a lawyer that Judge Boyd kicked out. It caused a ripple effect with some of Boyd's cases. I saw part of that, just a little bit. George is not frozen. George is not AI. George is a real person. He has super ability to hold still. So I can't leave the screen in case something happens. There's a guy in the background, probably cleaning up the crime scene back there. I wonder if he's going to come in the Oh, he's peeking. He's watching. He's checking. He's looking between the papers. Great disguise. Yes, podcast tonight. Can't wait. Thank you, Paula Mack. Tonight at 8 o'clock on this channel, Weather Watch and I, we go by Thomas and Scott on the podcast. We'll be doing a podcast. I was actually working on a story to put in right now, Weather Watch. I promise I haven't just left you in the lurch. We've got some fun stuff coming up. George blinked, and he moved. George is violating the statute of limitations. Yes. All right. So we are officially today, I should tell you, we are officially still on our decompression day. Bless you, Dennis. Bless you. We're still on a decompression day, and we're going to be starting a new trial on Monday. So we've got a little bit to talk about. I've got a ruling to read, and I might open up the phones just to talk about that ruling, but we'll get to that when we get to it. First, we've got a couple little court cases. Judge Boyd has had some crazy stuff. She did have somebody who impersonated a lawyer, which was just bizarre. It was crazy. I think the guy got trespassed from the courthouse, so he can't go there unless he has to, which sometimes I guess he has to. Looks like the raincoats are for cleaning up messes with spray bottles hanging close by. Oh, we've got two people in there. Is this at a jail? MDOC AMF. What could MDOC AMF stand for? We've got to figure out who this Curtis Smith guy is. The guy in the white T-shirt looked like that might be like inmate clothing. But this definitely is not a high security type scenario. I mean, the filing cabinet's not even locked. That top drawer looks like it's left open. Brooke, we're not going to be following the Adam Montgomery murder trial. The trial, addressing the Harmony's disappearance. There are a couple good channels out there to follow. They're different than mine. Obviously, they're different. Ikadmel, I think, is covering it. Melanie Little is covering it. There are a couple others. Do you have a delay on this case if something happens? Yes and no. Yes and no. I can shut down the stream if I need to, but I can't edit something out if a bad word happens. George has now gone into a trance, I think. Oh, we're reading some action here. Oh, loud courtroom. I see Vincent. Department of Corrections, AMF. Good morning, Andrew. Welcome. Hello to Perth, Australia. There's our first inmate. I'm not sure why he doesn't get the comfy chair. So we've heard that there's I'm not sure if it's a carjacking or a police car theft case that's going to be handled in this court this morning.
Good morning. You may be seated. Mr. Ganatra, start us off, please.
Good morning, Mr. Ganatra, Senior Assistant Prosecuting Attorney for the People. Your Honor, at this time, the people look for a conflict between the Honorable Court and the Office of Public Defender. The Prosecutor's Office does not believe a conflict exists. But if there is one present, we may call the cases today between the Prosecutor's Office and the Public Defender's Office before this Honorable Court. Thank you.
Thank you, sir. Mr. Brown.
Good morning, Your Honor. And might I say that maize and blue just fits you.
I almost didn't wear this today because of you.
Warren Brown, Deputy Chief Public Defender. Your Honor, we likewise do not believe that any conflict exists in this honorable court hearing these matters. If a conflict were to arise, we would waive that conflict so that this honorable court could hear these matters.
Court, for its part, also does not believe the conflicts exist either under Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case People of the State of Michigan versus George Allen. Is it Waluzak?
Good morning, Your Honor. Ken Thompson, Central State Attorney of the People.
Good morning. Great.
Morning, Your Honor. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Walczak. Mr. Walczak, will you please state your name for the record?
George Walczak. George Walczak.
Thank you, sir.
Your Honor, at this time, I'm asking for an adjournment. I did have an opportunity to speak with my client this morning, but we do need some additional time to review the discovery in this matter with him. If the court would allow potentially a 4-week adjournment.
You want 4 weeks out?
Yes, please, Your Honor.
No objection to the adjournment.
All right. Probable cause conference will be adjourned to March 7th, 2024, 9 a.m. Bond on this matter will continue. Thank you. Seriously.
George is like, I sat here still for like half an hour for this. Now I have to wait 4 more weeks.
And
4 more weeks for a probable cause hearing. I wonder what it's over.
131. Court does call the case of the people versus Curtis Smith. 2 cases.
How's it going, Honor?
Andrew Childers on behalf of the people.
First Assistant Public Defender Plea Anderson on behalf of Mr. Smith. And Your Honor, I too like your shirt this morning.
Thank you. Mr. Brown.
Very, very fashionable this morning, Your Honor.
What do you?
Well,
What do you
okay. Your Honor, when I called MDOC, I was told that Mr. Smith was not there and had been transferred out. So I did not speak with him this morning. I'm asking for an adjournment to speak with him.
All right. 20 seconds.
And Your Honor, if we can confirm where he is, the number that we had said he was transferred to Baraga, and I don't know that that's what's on the screen.
Mr. Smith, what facility are you? What facility are you in currently?
They transferred me to Burger.
Okay, that's what I have.
Got it.
Yeah.
All right. Probable cause conference in this matter will be adjourned to thank you. February 22nd, 2024, 9 a.m. Bond continue.
Let's see if
February
Dennis.
22nd.
Yes, sir.
Let's see if Dennis is
Okay, I appreciate it.
All right. Take care.
Yeah.
The court's quieting down.
Or that's called the case. People versus Theophilus Smith.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, this matter is before the court today, both for a competency hearing and a probable cause conference. We did get a report on competence. I've read the report. I have no reason to question the contents of the report. Ms. Barroso,
I don't have a report.
I believe she has an extra copy, Your Honor. We would stipulate to its admission, Your Honor. I knew, so we're going to see.
Okay. It's on the back.
No, it's not going to happen.
Well, he's reading that. Let me show you the interest counter really quickly. Ready? Because we did go over $1 million last night. The interest counter is up over $1 million. $1,020,000.
Any additional evidence from the people?
No, Your Honor.
All right. Court, upon reviewing the report, would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. I'll need an order filed.
Your Honor, normally I would say I would get that, except I'm going on vacation. But I'll get someone to get it from Mr. Bennett, or somebody will get it.
Okay, good enough.
Okay. Now, Your Honor, having said that, we did get a letter from the Center for Forensic Psychiatry. They are going to be doing a CR on him, but they're going to need some time. They say they're way backed up. Ms. Barroso and I talked about maybe a 60-day adjournment on this.
Is that where the April 18th date?
I didn't see that date in there, Judge, but
I think there was an attempt to yesterday try to stipulate this out to April 6th, April 18th.
The case we're looking for.
Let me check my calendar, Judge.
Judge Simpson is Bridget Williams. Bridget Williams is the one we're trying to get, I think. She should be on the schedule today.
Yeah, that date would work.
All right. Probable cause conference then will be adjourned without objection to April 18th, 2024, 9 a.m. Bond will continue.
Can I speak, Your Honor?
He's going to ask for a bond, Your Honor, and I told him that given the nature of the charges and given the examination that needs to be done, that would not be granted. That's what he wants to address the court on.
I was just going to ask if I can get let out on the GPS teller and the $1,000 bond.
$1,000 bond?
Yes.
On this offense? That won't happen, sir. Bond will continue. Thank you.
That won't happen. I don't know what the offense is, but apparently not going to happen. Never hurts to ask, though. I mean, the worst thing could happen
Pause case, other people versus Brennan Cooper.
Mr. Ganatra, Senior Assistant Prosecuting Attorney for the People.
David I. Goldstein appearing on behalf of the defendant. Mr. Cooper is approaching the podium, Your Honor.
Your name, sir? Brennan Cooper. Thank you. All right, what are we doing?
Your Honor, Mr. Ganatra and I have had an opportunity to discuss this matter. We have not yet reached resolution. We both think it would be best to go ahead and set this for a prelim, but knowing that I'm going to be gone for a while, that'll give Mr. Ganatra an opportunity to do what he needs to do to
where he's going
to move forward with the negotiations.
So discovery is complete?
Yes, Your Honor.
When were you looking?
Late March, Your Honor.
What do I have late March? I have 12, then I'm going to have the 19th. 19th or 26th?
26 works for me, Your Honor.
That objection, preliminary examination will be set in person. People presumably will have their witnesses available that day.
Yes, Your Honor.
March 26, 2024, 9 a.m. before Judge Washington.
Melanie, that Montgomery trial is a tough one, especially if you're a parent, grandparent.
Bond will continue.
It's really, really tough. Hank, welcome. Thank you for the super chat, my friend.
Court calls the case of the People versus Ellington Haynes.
Here's what I like. Look at Dennis. Look at
Good
Dennis.
morning, Assistant Attorney General Emmanuel Owusu-Coker on behalf of the People.
Good morning, sir.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Haynes. Would you state your name for the record, sir?
Yes, Ellen Haynes.
Dennis is wearing the
Your
proper
Honor,
attire.
this time we are asking for
Proper
a
frame.
short adjournment. I did get to talk to Mr. Haynes a little bit about some of the things that I was able to speak to the AG's office about. And I would like an opportunity to try to work on some of those issues and see if we can get him a positive resolution. So we're just asking for a 1-week adjournment.
February 15th, 2024, 9 a.m. Bond continued.
I don't know what Dennis is here for, but he's got the camera.
Thank you.
Thank you.
He's right centered in the camera. He's paying attention. The lighting is good.
Court calls
He has a
case People
ceiling
versus
fan.
Stephen Neely.
He's dressed as good as anybody who showed up in court.
Attorney Morgan Rosa, on behalf of the people.
I'd move for
David
dismissal at this
I.
point.
Goldstein appearing on behalf of the defendant. Neely is approaching the podium, Your Honor.
Your name? Stephen Neely. Thank you. All right, what are we doing?
Your Honor, we likewise, in this case, we need to set this for a preliminary examination.
Discovery is complete?
Yes, Your Honor.
You want that same day?
That'd be fine, Your Honor.
All right. People will have their witnesses available the 26th of March.
Yes, sir.
Preliminary examination will be set in person, March 26th, 2024, 9 a.m. before Judge. Me?
Yeah.
Really? Please.
Yeah.
Okay, before me.
So plot twist. Dennis House goes pro se.
And we'll continue.
If he goes pro se.
Well, the show,
That'd be crazy.
Thank you. Appreciate it.
Gets me.
Court calls the case, People versus Michael Brooks.
Assistant Prosecuting Attorney on behalf of the people.
Good morning, everybody. On behalf of Mr. Brooks. Your Honor, today's time and date for a PCC in this matter. I was just appointed. I want to talk to Mr. Brooks a little bit more about this. Can we adjourn this possibly 1 week?
Sure. Without objection, probable cause conference, February 5th.
Okay, well, Mr. Brooks wants to proceed to preliminary exam, Your Honor. Sorry.
Is discovery complete?
It is with me. I don't know if he's got everything, but I gave him some of the stuff.
He's like, can't we just move this along?
Judge, the only thing, the week of the 20th, I start a trial in circuit court, so could it be after that, please?
This defendant is not big fans.
People have their witnesses available the 27th.
I see you're trying to.
Yeah. But no, we should have thought of that before you said something. Judge, can we go on the 27th?
Look at the judge's face.
Yes. I was just going to do that.
Oh, I'm sorry. I thought you did say that, Dane. I'm sorry, Your Honor.
Preliminary examination will be set in person, February 27th, 2024, 9 a.m. That will be before Judge Barr.
Thanks, Judge. I'll come see you this week.
On continue.
Thanks, Judge.
Thank you.
The judge doesn't like people choosing
Court calls the case, People versus Tyler Watts.
David I. Goldstein is appearing on behalf of the defendant. I have not. There may be some confusion because the last time we were here, he came at 2 o'clock because he was set for 2 o'clock. And I don't know that he knows it was supposed to be 9.
I told him 9 o'clock.
I know you did because I wrote down. I always write down 9 o'clock, even though I know they're going to get moved later. But I have not seen him, Your Honor. I can try to call him. If we find him by noon, I'll bring him back. I have to go somewhere else. I got to go to the doctor, but I should be done, and I can come back and if I can get a hold of him. Otherwise, I assume you'll issue a warrant.
Well, here's what I'll do. I'll issue a bench warrant. If he shows up, we'll do something with that. But at this point, I'll issue a bench warrant for defendant's failure to appear. Bond set in the amount of $10,000 cash surety. That warrant will issue immediately, but we'll hold it and see what happens. All right. Bless you, whoever that was. Court calls the case of the People versus Amy. Is it Brewstall? Brewstall?
She's in custody. They're not.
They haven't brought her yet. Okay. Court to pass that matter briefly. Court does call the case People versus Chelsea Carr.
Image Ganache, Senior Assistant Prosecuting Attorney for the People.
We need to get some of these people out of the court.
Sam Bernstein for Chelsea Carr, Your Honor. I didn't know that Ms. Carr was here. I called the name a couple of times.
Sorry. I went to the court.
Oh, that's okay. Your Honor, can we have a 2 or 3 week adjournment and then we can go speak in the hallway?
Okay.
Probable cause conference will be adjourned to February 29th.
Thank you, Your Honor.
2024, 9 a.m. Bond continued.
Thank you.
Thank you.
They got her. Court calls the case People versus Amy Brewstall.
Good morning, Your Honor. Christina Costantino appearing with and on behalf of Amy Brewstall, who's present and standing to my right.
All right. Your name, ma'am?
Amy Brewstall.
Thank you. What are we doing?
Your Honor, it's the date and time set for a probable cause conference. I was just appointed yesterday, I think morning. And at this time, I do not have any discovery on this matter, given my appointment of yesterday. So we would be asking for another PCC.
Probable cause conference will be adjourned to February 22nd, 2024, 9 a.m. Bond continued on the
Judge, may I address bond?
briefly.
Thank you, Judge. My client is currently 29 years old. It's my understanding she has no prior assaultive criminal history, and the extent of her criminal history is a OWI from 2016. So she has gone many years without any negative encounters with law enforcement. Should she be released, she does have a place to live. She would be living locally in Ypsilanti with her significant other's mother and her significant other's son. She would also be serving as a caretaker for her significant other's elderly mother. She, prior to being arrested on this case, was applying for employment at Kroger and was going through the hiring process. So she is hopeful she would be gainfully employed through Kroger. She also serves as a chair for AA meetings that she attends every Monday, and she's been doing so.
When this occurred, was she on bond?
I don't believe. Were you on bond?
Judge
No, Judge.
cuts through the
She
crap.
has nothing else pending, no warrants. She's not on probation, nothing to that effect. Her most recent prior, as far as I'm aware, was from 2016. And she successfully completed probation, and that was a misdemeanor first offense OWI.
Response from the people.
The only thing I would say is that it was Ms. Russell was sentenced to probation in 2017 on the drunk driving. That is the last criminal contact that I showed at the time of the offense.
Do they have the wrong bond form in here then? Yes, they do. And we got the wrong bond form.
And I'm not sure where this information came from. But in reviewing the bond form, my colleague, Ms. Hughes, noted that she showed a fail to appear bench warrant out of Westland for this $5,000 bond. It was a larceny charge.
She's
That's
shaking her
what
head, saying,
I
that's
have.
not me. That's not me.
But
I think that they called Westland and listened in.
that's why I asked. I have an arrest out of Westland and also a Madison Heights matter.
So, Judge, it's my understanding that the Westland matter, I don't believe they will be picking up on that. And my client was under the impression that the warrant in Westland was canceled. I do believe that is a misdemeanor warrant, if it is at all a warrant at this point.
Right, but that's what I guess I was asking about. Was she on bond at the time of this alleged offense? Because I have that she would have been on 2 failure to appear bench warrants, one out of Westland and one out of Madison Heights.
I didn't even know about Madison Heights.
This is the first we've heard of anything out of Madison Heights, Judge.
For a drug paraphernalia charge.
Oh, they told me they didn't want that. When I got arrested, they said that there was they called those, I don't know, they didn't want.
So, Judge, it doesn't sound like she was necessarily on bond. I don't believe she ever went to court for either of those 2 cases.
Oh, that's better.
But I don't know if there was a bond. It's my understanding that my client wasn't aware of Madison Heights warrant and that she thought Westland was taken care of.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.
Sometimes it's a puzzle you have to put together. Judge found all the pieces.
Wow. Court does call the case People versus Jasmine Neal.
We're hoping for a Bridget Williams, I think, is the case we're listening for, that involves a stolen police car on a 45-mile joyride.
She.
Yeah.
It almost worked for that defendant. I think they almost got
Hold
bonds
on,
and got out.
who's this? Well, let me get the in custody. Let me. All right, I just called the Jasmine Neal case.
Right on there, Your Honor.
They stated it a long time ago. Why we?
Okay. Good morning, Your Honor. Marcia Krejci on behalf of Ms. Neal. Ms. Neal, can you please state your name?
Jasmine Neal.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, this indicates that the defendant will be pleading no contest to an added count 3 of child abuse 4th degree, the 1-year offense. Upon her successful plea to that charge, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
That's a correct resuscitation.
May I have her sworn?
Right. You solemnly swear affirm the testimony you're about to give, the whole truth and nothing but the truth, so help you God.
Yes,
State your name.
Jasmine Neal.
Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of child abuse 4th degree. Is
Yes,
that your understanding?
yes,
All right. That is a misdemeanor punishable by up to 1 year incarceration. I don't have the maximum fine on this.
I think it's $1,000, if I'm not mistaken.
That's what you have. All right. Incarceration up to 1 year or 5 years probation. You understand that, ma'am?
yes,
All right. Do you understand what a no contest plea is?
yes.
Let me explain 2 things about a no contest plea just to make sure that you understand. The first thing you need to understand about a no contest plea is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yeah.
I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, ma'am?
Yes.
Basis for the no contest plea?
Potential civil liability, Your Honor. There's a neglect and abuse case that's currently open.
Ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
Has she signed an advice of rights form? Probably not.
I'm not
because
sure.
you weren't in here. Ma'am, because you're not having a trial, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything
No.
other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
The court has been handed and has reviewed Ann Arbor Police Department report for their case number 2332076. Any objections to the court having reviewed that report?
No objection, Your Honor.
Based upon the court's review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
March 1st at 8:30 before Judge Perry.
March 1st, 2024, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you, Your
Court calls the case People versus Candia Roper.
Mr. Sinatra, Assistant Prosecutor, ready.
What's his name?
Good morning, Your Honor. Marcia Krejci on behalf of Ms. Roper. That's the waiver.
Okay, what are we doing?
Your Honor, this is going to be a waiver up to circuit court, Your Honor. Yes, sir.
Ma'am, you heard what your counsel indicated?
Yes, sir. Waiving my preliminary exam.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Creed.
Your Honor, we acknowledge receiving the information. We waive its formal reading and ask the court to enter and allow my client to stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
February 26th at 1:30 before Judge Slade Monday.
February 26, 2024, 1:30, Slade Monday.
Thank you, Your Honor.
Thank you. Bond continue.
I have no bond.
Court calls the case, people.
I'm sorry, may I tell you?
Yes. Court calls the case, people versus Benny DeNovi.
Good morning, Assistant Attorney General Emmanuel Owusu Coker, behalf of the people.
Good morning, Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. DeNovi. Would you please state your name for the record, sir?
Benny DeNovi.
Okay, thank you.
Your Honor, when we were here last time, we discussed that Mr. DeNovi had a pending hearing before the referee with a friend of the court regarding his child support. The hearing has been held. He has not yet received the recommendation. It is in the mail, so we're asking for a week or two in order to give us some time to receive it.
Without objection, probable cause will be adjourned February 22nd, 2024, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus John Whiteowl.
David I. Goldstein appearing on behalf of the defendant. Mr. Whiteowl is at the podium, Your Honor. We're going to be waiving exam, Your Honor. He's executing the waiver.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes, sir.
And you do understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
People also waive their right? Preliminary examination having been waived, defendant is bound over to circuit court on all 9 counts.
Your Honor, my client and I acknowledge receipt of the information in this matter. We waive its further reading. My client stands mute, asked and not guilty plea be entered.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial will be set for
February 21st at 1:30 before Judge Conlon.
February 21st.
I'm sorry, you said Conlon?
Yes.
2024, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you, Bond. Yes, Bond in this matter will continue.
Your Honor, that other matter that you called Watts, I spoke to Mr. Watts. He thought it was this afternoon. He's on his way. I have to leave. Mr. Killawald is going to take care of the matter when he gets here.
Okay, very good. We probably need to get that file back.
His cruise ship is waiting. He needs to get out of here, going to vacation.
Mr. Goldstein, what was the client's name again?
Taylor Watts.
Taylor Watts. We have the file. I don't know if we still have it. I issued a bench warrant for it, but court calls the case, people versus Marcus Thompson.
Good morning, Assistant Attorney General Emmanuel Owusu Coker, behalf of the people.
The public defender Hannah Apple appearing on behalf of Mr. Thompson. Mr. Thompson, can you please state your name for the record?
Marcus Thompson.
Thank you. All right, what are we doing?
Your Honor, today's date and time set for an adjourned probable cause conference. At this time, we are asking for an adjournment. Mr. Thompson is making payments towards his arrearage, but he does need some additional time in order to get that amount down to the $28,000 in order to reach a resolution on this. I would ask if the court would allow for 4 to 6 week adjournment.
Marcus is a FedEx driver.
No objection, Your Honor.
Public cause conference, March 21st, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Are you calling Watts for Mr. Goldstein? Is that what you?
Yes, it's gonna be a week, not right away, because I don't know where he is.
Okay, no problem. We'll hold on.
Mr. Killawall's gonna handle it for Mr. Goldstein. Court calls the case, People versus Edward Newland.
Marcus needs to hang up. There we go.
Good morning, Your Honor. Amy Reiser.
Good morning, Your Honor. Michael Vincent on behalf. We are waiting for a report from the Forensic Center.
It's Vincent.
Still.
When we referred my client to the Forensic Center, I didn't have any gray hair. So it's been a while.
It's been a minute. All right. What I will do then, what I've been doing with these, because I realize they're backed up on the reports, is adjourning out a month. If we get it before then, we'll set it.
Thank you.
But I'll set this then for March 7th, 2024, 9 a.m. Thank you. Bond will continue. Yes. Court calls the case, People versus John Shoemaker.
Attorney David
Good morning,
Cripps.
Your Honor. Attorney Ryan Ramser, P73195. On behalf of Mr. Shoemaker, is making himself up here to the lectern.
You said lectern, not podium.
Your name, sir?
Identify yourself, please.
John Shoemaker. Thank you. What are we doing?
Your Honor, if we could set this for preliminary examination, please.
Discovery complete?
It is, Your Honor.
People would have their witnesses available on the 20th.
Would it be possible to do a different day than that, Your Honor? I do have a conflict.
Wow, a brief momentary pause and there you go.
Yeah.
The 27th in the morning would be available, Your Honor.
People have their witnesses available that day. All right. Preliminary examination will be in person, February 27th, 2024, 9 a.m. That is before Judge Washington.
I think Attorney David Cripps.
Bond will continue.
Moonlights at the local
Thank you very much,
theater.
Your Honor. Love your shirt. Thank you.
Thank you.
Love your shirt. Thank you. You're supposed to say that before you ask for a favor.
Court calls the case, People versus Anton Brooks.
Senior Assistant Prosecutor.
Good morning, Your Honor. Erica Julian, substituting in on both cases. There should be orders for Your Honor to sign in the file. Mr. Brooks.
Please tell me it's not in a bathroom stall.
Thank you. We're requesting an adjournment of both matters so I can obtain discovery.
Please tell me Attorney Cripps is not in a bathroom stall.
Probable cause conference, February 22nd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor. All right.
Okay. The way that was sitting, I thought the walls were were different. I thought not a camera over his head, but like a fan of some sort.
Court does call the case of the People versus
David. David's been so good, Judge.
Arthur Herndon.
Good morning, Roger Cole on behalf of Arthur Herndon. Arthur, would you state your name?
Arthur Herndon.
Judge, this is set for PCC. I spoke with Ms. Reiser. We'd asked to adjourn this out 30 days, Your Honor.
No objection.
Probable cause conference will be adjourned March 7th.
Mr. Herndon previously had a preliminary examination. Yes.
The court clerk comes in with some clutch info here.
Right.
So just.
Got it. Okay. March 7th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor. Okay. Give me a call.
Court calls case People versus, is it Zycala Whitsett?
Mr. Cripps is dangerously close to the camera. Dennis is uncomfortable.
You don't have her up.
He's been sitting for a long time.
Nimish, that's yours.
Go to pass that matter. Court calls case People versus Veronica Webster.
On behalf of the people.
She was just here.
Yes, Your Honor. If I may, This was a case that belonged to Ms. Garrett Carragher, and there was some miscommunication about whether or not permission to appear via Zoom had been given by whether a request had been submitted by Ms. Garrett Carragher or not. Ms. Mood is covering, and she was hopefully going to get her client to sign on via Zoom.
Braxton, good morning.
That's the phone call she's making right now.
It was good to talk to you last night.
Not
Thank you,
here.
my friend.
That's correct.
And Ms. Hamoud's not here.
Ms. Mood was just in here. I believe she's on the phone now trying to get her to sign on via Zoom.
Fine.
We'll pass that one for just a little bit. No
I
bench
guess I'll
warrant.
pass it. Who's this? What's that? Okay, I'll pass that. Fine that you show up. Hi.
She walks in
I
late.
am, this is not Ms. Webster. I'm trying to get her on right now.
Oh, okay. If I had known that, we wouldn't have gotten you.
I'm so sorry.
Ms. Barroso was saying you were just like lounging out in the hallway.
Yeah.
I mean, it was
Usually
horrible.
what
The
I
whole
do.
thing. I defended you. I did, but all right. I'll pass it.
Thank you.
Court recalls the case of the people versus Zakila Witsa. One is under the name of Zakila Hill Witsa.
Senior Assistant Prosecutor.
Morning, Your Honor. Rev. J. Kill on behalf of Ms. Hill Whitsett. Would you state your name for the record?
Kyla Hill, is that?
Judge,
Hold it one moment. I've got you, I think, on one case. Have you ever gone by Zakila Hill Witsa? Yes.
Yes.
Is that your sister's name?
No.
So I have you on one case. I have Miss Apple on the other case.
Is that your sister's name?
Your Honor, I
Judge throwing
thought
the
that I
client
received
under
a
the bus.
substitution from.
We only have it on one for whatever reason. Yeah, I only have one, I think, on 88. I don't.
Yeah, Judge, it may be my oversight then. I just thought I was appointed. I was just appointed on the one case.
0088, correct?
Yeah.
88 was in 0088 was the one that Mr. Killowald was appointed on. The other case still has the public defender.
Judge, can you tell me what the bond is on 088?
Here, let me Google that for you, says the judge.
2,000 cash security.
Your Honor, as far as the 088, I was just appointed. I just got the discovery. I'd like to discuss this with Ms. Hillwitz more. Is it possible to adjourn it 1 week? And I have a bond request if the court would.
Would the people be ready? I mean, not the people, but would the public defender be ready in a week or?
Yes, Your Honor.
Both of these matters, probable cause conference will be adjourned 1 week to the 15th.
Judge, as to bond, my client informs me that she has some circuit court matters where she believes her attorney there, Rita Young, will be requesting a PR bond. So in this case, I'm asking the court if it would please consider reducing the $2,000 cash bond to a nominal bond in case Ms. Young is successful in reducing her bond in circuit court.
Judge Laurie is shaking his head.
Response from the people, I'm not sure why I would do that if her bond isn't reduced, but is there a response from the people?
Every cases in circuit court. Felonious assault. She has a pending retail fraud second district court.
Personal recognizance.
This case that we have here today, the intention would be for the people to add a count of possession of cocaine under 25 grams. And on her criminal record, there's 8 prior misdemeanor convictions. I can go through them if you want.
Yeah, I don't know. She's got a bond up in circuit court at this point, but if not successful, then she's going to sit on a PR. I'm not going to reduce her bond. Motion for bond reduction.
I was just asking for a nominal bond, not a PR bond, but thank you, Your Honor. Appreciate it. Consideration.
appreciate the consideration. None was given.
Court calls case People versus Mohammed. Is it Haji Jelani?
Image Ganatra, Senior Assistant Prosecuting Attorney.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Haji Jelani. Mr. Haji Jelani, please state your name for the record.
Mohammed Jelani.
Mr. Jelani, welcome back.
How you doing?
Hands out of your pocket.
That's the date and time set for a probable cause conference. This time my client wishes to waive his right to a preliminary examination, have the matter bound over to circuit court for further proceedings where he has been accepted into the felony drug court.
All right, Mr. Jelani, is that correct?
Yes, Your Honor.
Understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it.
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court.
Yes, Your Honor.
People also waive their right.
We do.
Preliminary examination having been waived, defendant's bound over to circuit court on a single count.
All right, waive formal reading, acknowledge receipt of the information. My client would stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea pre-trial, and this matter will be set for
March 18th at 1:30 before Judge Slay Monday.
March 18, 2024, 1:30, Slay Monday.
Gentleman, may I sign the information?
Yes, sir.
Thank you, Your Honor.
Thank you. Court does call the case People versus Mark Rassman.
Dennis is getting frustrated.
On behalf of Mr. Rossman, Your Honor, this is
Good morning, sir.
PCC. Good morning, Your Honor.
Sir, you need to face forward. Your name?
Mark Raven.
Your Honor, we just got discovered this morning, and I have not had an opportunity to go over with my client. I'm asking for a 1-week adjournment for the PCC. Is that possible?
Yeah, it's possible, but okay.
The 15th, and I'd like to speak to bond if I may.
You may, go ahead.
Your Honor, my client has no criminal record whatsoever. The bond is extremely high, $100,000.
What's the crime?
He has no criminal record whatsoever. Works with his dad in construction. I'd ask for at least, Your Honor, a $20,000, 10% bond. I think that's reasonable.
Probable cause conference is adjourned out a week to the 15th. It's 9 a.m. Response from the people.
It's true that the defendant does have no criminal record. However, it is $100,000 with 10% privilege in this case. As the basis for that bond request was the allegations, and then he showed up to his ex-girlfriend's house. He left his TV outside the house because he knew he was on the way and she didn't want to see him. When he arrived, he started banging on the door. She opened it a little bit. He pushed his way in, put his hands around her neck, pushed her across the room, and started yelling at her. This was in front of the victim's brother, who tried to separate the two and stop the defendant. The police were called, but the thing that's the most concerning is the statement that he made on his way out, where he told the police that for the shit I'm being charged with now, I should leave that shit out. It's concerning that the initial incident of physical violence and aggression was not enough for the defendant. We are concerned that if he's out, he would immediately return to the victim's residence, not just by his own actions, but that's what he said.
Well, Your Honor, the parties used to live together. This is a domestic violence case at best. She opened the door, and he walked in. They used to live together. They lived together for 4 months, and they had only parted a week before. So he's overcharged, number one, and the bond is extremely high.
It's extremely high, but also, I guess, once
he basically said, if I'm getting charged for this, I should have
after this
treated
incident
her worse.
And he was arrested, he got to the jail and then started calling the victim in the case. Are you aware of that, Mr. Green?
Say that again, Your Honor. I probably.
And after he got to the jail,
witness tampering,
he started calling the victim immediately, and the magistrate was. had to deny his phone privileges because of his repeated contact or attempted repeated contact with the victim in this case.
It's my understanding that the contact was simply for her to contact his parents because that was the only number that he knew. He actually lives in New Jersey.
Pardon?
I was saying he lived in New Jersey. His parents are in New Jersey, so he was calling her to contact his parents in Jersey, let him know that he was being locked up.
Still not okay.
But it was not of an assaultive nature at all, Your Honor.
Still not okay.
And certainly there was no.
Well, how long has he been in our state? Because I have a New Jersey address for him. I don't even have a Michigan address for him.
They live together in Michigan. Where'd you live in Ann Arbor?
3617 Wheatburn Court.
677.
Wheatburn Court.
Hey.
About a year, Your Honor. A year. They were living together, boyfriend, girlfriend.
Well, I understand that, but I have a New Jersey address for him. I don't have a Michigan address for him.
That's
number one. Number two, the other thing is.
3617 Wheatburn Court, Your Honor.
Pardon?
3617 Wheatburn Court.
Where the incident happened.
I guess the other aspect is that after, I mean, the comments that were made in this case, I think are a bit alarming. And then after being arrested, there's then contact with the victim in this case. And that is troublesome because I don't believe that, or at least leads the court to believe that if I were to release the defendant, that he would not be able to follow the court's orders regarding this.
Your Honor, if I may, the address that is also being stated as the defendant's address is the victim's address and the occurrence of where these events happened. So that just further exemplifies our concern for him returning and having additional contacts with the victim.
Your Honor, there was
where would he go, Mr. Green? If he were released, where would he go?
Hotels. I can live with friends.
He's got friends here, Your Honor. He can go to a hotel. His parents will put him on.
I mean, I may look at it again if there's an address that he goes to, but I'm disinclined to grant his release at this point.
But I'm just asking for a reduction, Your Honor. Even a $20,000 10% bond. That's $2,000. That's a reasonable bond.
Well, I don't know that it's a reasonable bond given the circumstances and the fact that I don't know that this defendant even resides really within this state, Mr. Green. I mean, that's part of my problem. I don't know where he will go. So at this time, he's coming back in a week. If I have additional information, I'll take a look at it again. But right now, motion for bond reductions denied. Bond will continue.
I'll get it to you, Your Honor. Thank you very much.
Yeah. Court calls case, People versus Dennis House.
Oh, Dennis, you're up. Dennis, this is your moment.
I'm here, Your Honor.
Attorney for the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Mr. House. We both appear via Zoom. Thank you for allowing that. We consent. Dennis, please state your name for Judge Simpson, the prosecutor, to know you're here. My name's Dennis Michael House. Thank you.
What are we doing?
Your Honor, I'm asking for a 30-day adjournment. I'm trying to work out a global resolution with his Wayne County matters. We do intend to waive the preliminary exam when we get to that point, but I'd like to try to negotiate first, Judge.
Any objection from the people?
No.
William
Probable cause
William
conference,
there's
March
busy
7,
negotiating the I-94.
2024, 9 a.m. Bond continued.
Thank you.
Thank you.
William's like, I got all
Court
dressed
calls
up for
case,
this.
People versus Thomas T. King.
Is he going to hang around for a few more?
Good morning, Your Honor. Amy Rides on behalf of.
Good morning, Your Honor. National Attorney with and on behalf of Mr. Teaking, who is present to my right. Mr. Teaking, can you please state your name for the record?
Yes, ma'am. Thomas Taking.
Sir, we would like to set a matter for preliminary exam.
Both cases.
Yes, Your Honor.
Discovery complete on both cases.
As far as I know, but We have everything that,
You have all the videos.
yes, yep.
Dennis
I
is
did
leaving.
indicate prior to council coming on the case that I believe the evidence in the case will support an additional charge of assault with intent to murder, and I would plan to move to add that if the testimony is supportive of the charge.
That's correct, Your Honor. We did have that conversation.
Assault with intent to murder.
People have their witnesses available on the 20th?
February 20th?
Yes.
He is unavailable. Yes, February 13th and 15th, but the 20th is good.
Thank you, Your Honor.
Preliminary examination will be set in person February 20th, 2024, 9 a.m. before Judge Burke on both matters. Bond continued. Thank you.
Oh, thank you, Your Honor.
You're welcome.
I'm not sure if Dennis is thinking he's going to get recalled here or what, but he's hanging out for the long haul. I guess he found court as interesting as we do. A global resolution would mean there's like multiple cases, and I think they're trying to find a solution that would be happy with
Court calls the case of the People versus Jeffrey McDaniel.
Ready, Your Honor. For the people.
Counsel, state your appearance, please.
Good morning, Judge. David Cripps, P 34972, appearing on behalf of my client, Jeffrey McDaniel, who's in the courtroom.
Sir, state your name.
Jeffrey McDaniel.
All right. Thank you. What are we doing?
Your Honor, I just got retained on this case. I'm asking for an adjournment so I can acquire full discovery and go over it with my client so we can decide what to do on this case. I heard you mention the date of March 7th. Is that possible for an adjournment?
30-day adjournment? What's the reason for a 30-day adjournment on this?
I think it's somewhat of a complicated case, and I need to get discovery and go over it completely with my client, Your Honor.
Any response to a 30-day adjournment from the people?
Here every week, Your Honor.
Probable cause conference, March 7th, 2024, 9 a.m. This matter will continue. And counsel, Mr. Cripps, I just appreciate it that when you call my clerk's office to address them, that you be kind to them. They will help you out as best they can. But I don't like getting that type of report. I don't need a response from you and really don't want one. I am just giving you that admonishment. Thank you.
Thank you, Your Honor.
Oh.
Court calls the case, People versus Anthony Murphy.
He was the rude guy on the phone. Don't tick off the judge's clerks.
Good morning, I'm Rob Dickill on behalf of Mr. Murphy. Mr. Murphy, would you state your name for the record?
Anthony Murphy.
Judge, I'm not ready to say this, but can we have a 30-day adjournment? I've discussed this with the prosecutor.
Judge throws his pen.
It's for further discovery in the interest of justice.
You thought that last thing would really matter.
I heard that on Perry Mason.
Heard that on Perry Mason.
Any objection from the people?
Your Honor, Mr. Kilwell makes a compelling argument. I don't have an objection.
I'm not making fun.
Probable cause conference will be adjourned March 7th, 2024, 9 a.m. Bond will continue. Thank you.
Judge,
now you want to argue, Bob?
Well, it's my understanding he's got under $100,000 bond. All he was asking is the court would consider a 10% matter.
Any response from the people?
This is not such a compelling argument. Mr. Murphy doesn't have any contacts locally. My understanding is he doesn't have a place to stay or anything like that. His contacts are all out of the state. So I have a very serious concern for flight if he were to bond out. I asked that bond remain as set. All of his contacts I show are in the bond.
Where would he reside if he were released, Mr. Kilroy?
Your Honor, he has the cash ability to get a hotel room if that were the case, but he does not have any permanent residence in Michigan.
Well, hold it here,
Motion for
then.
bond reductions denied.
Thank you, Your Honor.
Court calls the case of the People versus Cora Daly.
He had one heck of a shiner, too, that last defendant.
Assistant Public Defender Jay Bellinger on behalf of Ms. Daly, who appears via Zoom. Ms. Daly, can you please state your name for the record?
Cora Daly.
Sit down, ma'am. Cora.
What are we doing?
Cora, have a
Your
seat.
Honor, I have submitted a waiver to the court. We plan on proceeding to circuit court from here.
Oh, she's finding her ceiling fan. That's good, Cora.
Ms. Daly, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes.
People also waive their right?
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 following.
Thank you. Your Honor, we would acknowledge receipt of information. I waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 4 counts. Pretrial will be set for
At 1:30 before Judge Slade Thursday.
March 14, 2024, 1:30, Slade Thursday.
Thank you.
Bond continued. Court calls the case of the People versus Michael Johnson.
Senior Assistant Prosecuting Attorney.
Good morning, Your Honor. Marcia Creighton on behalf of Johnson, who is making his way to the podium. Can you please state your name, sir?
Michael Johnson.
We've seen him before.
What are we doing?
Your Honor, Mr. Reyes was unable to see him but he had indicated to me he'll be seeing him tomorrow. We'll be respectfully requesting 2 things. One is a 1-week adjournment. And the second item is my client insists that I address bond.
My client insists. She's like, it's not going to go anywhere.
Mr. Reyes, if he
He's
sees
making
him,
me
is there
ask.
going to be a decision that we can proceed with this in 1 week?
Yes.
Probable cause conference will be adjourned February 15th, 2024, 9 a.m. As to bond, briefly.
Your Honor, my client, I have been in contact with his employer. My client does have a job that he can go back to with the apartment complex where he is a maintenance person, where he also, as part of his employment benefits, receives housing. Therefore, if he's incarcerated much longer, he will not only lose his employment, but also his housing, Your Honor.
Okay, compelling argument. What are the charges?
Response from the people.
Your Honor, I believe this was addressed last week. But
It was.
I'll restate. I don't think that the issue is as much of a prior criminal history, although he does have prior drug conviction on his record, his possession of meth, 2021 6th Circuit Court. It was his failure with community corrections to test leading up to middle of June. And I believe a court issued a bench warrant at one point.
Yes. He couldn't follow the instructions once he was released.
I understand, Your Honor.
Motion for bond reductions denied.
Thank you, Your Honor.
Bond will continue.
Thank you.
Attorney William Amedo looks like he's at a stoplight, but I think he's in the parking lot.
It's ready whenever you are, as well as that one.
They're both ready.
Yeah, they're both ready.
Court calls the case People versus Tyler Watts.
Oh, Veronica needs a recall. We'll see what happens there.
Good morning. I'm Rob J. Kill standing in for David Goldstein. Mr. Watts, would you state your name for the record? Tyler Watts.
Do you have any objection to Mr. Kilowald standing in?
No.
All right.
Judge, my client has signed a Mr. Goldstein's client has signed a waiver. He understands he has the right to have an exam in this matter. He's waiving that right. I want to proceed to circuit court.
Is that correct, sir? And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Sure.
And you understand that you will not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 and 3 following.
Judge, we acknowledge, receive the information, waive its reading. Mr. Goldstein's client would stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all 3 counts. Pretrial will be set for
March 27th at 1:30 before Judge Conlon.
March 27, 2024, 1:30 before Judge Conlon.
Thank you, Judge. You issued a warrant. Will that be recalled? Or you
Yes.
Okay.
That's the one who thought he was supposed to come in the afternoon.
Yes.
Dennis was charged with, I believe, a DUI and a multiple offense situation.
Oh, I see what you did.
Apparently, Veronica, if it's the same Veronica, home invasion, first-degree robbery.
Or first-degree home people invasion. Versus Darius Williams.
Thanks to Greeners, who's doing the digging here on these ones.
Andrew Childers appearing on behalf of the people.
Good morning, Your Honor. William Amadeo, P76194 on behalf of Darius Williams. I consent to Zoom. Thank you for allowing me to appear via Zoom. Darius, please state your name for Judge Simpson and Prosecutor Childers and know you're at the podium.
Darius Williams.
All right. This is date and time set for a competency hearing, and I do have a report on this one.
Yes, 2 things, Your Honor. One,
report as well would move to admit that in evidence.
All right. Mr. Amadeo.
Thank you. Your Honor, we're going to stipulate to the report, Your Honor. I'm going to, and I'll get you an order to that effect. We're going to ask for a PCC date in about 3 weeks. I know my client wants to address bond. I'm not going to do that today. I'll send you a written notice when I get approval from your staff and the prosecutor to give them time. So for today, Judge, just stipulate to the competency and ask for 30 days or 21 days on a PCC.
My client wants me to address
the
bond.
Report
I'm not going
indicates
to
that
do
the
that.
defendant is competent to stand trial, specifically that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent in this matter. I will then set a probable cause conference out. March 7th work.
Yes, Your Honor. Thank you.
March 7th, 2024.
What kind of
9
car is
a.m.
that?
bound continue.
The attorney.
Have a good day, Judge. Thank you.
Thank you.
I'm thinking that looks a lot like the one I took
Recalls
down, like
case
the Audi
versus Veronica
that I
Webster.
took down to Florida.
On behalf of the people.
Ms. Abood is involved in an interesting conversation with Mr. Brown, so apparently she's not paying attention. He does that to, that's okay.
Look at me all nervous. Good afternoon, morning. Janan Hamoud appearing with and on behalf of Ms. Webster. I was getting a very important lesson on 403B evidence from 404B evidence from Mr. Brown.
Oh, boy.
Yes, Ms. Webster is present and by Zoom. Ms. Webster, can you please state your name for the record?
Veronica Webster.
New York mom, welcome.
And we
Thanks
thank
your
the
second
court
month
for
of support.
allowing the Zoom accommodation on her behalf. Ms. Webster would like to schedule her case for preliminary examination, and I believe all discovery is complete in this case.
All right, would the people have their witnesses available the 20th?
Yes, Your Honor.
Preliminary examination will be set in person February 20th, 2023, 9 a.m. before me.
Ooh.
Bond
Your
will
Honor.
continue. Thank you.
Thank you, Ms. Webster.
Thank you, Ms.
Thank you.
Court calls the case people versus
Who's next? Who's next?
Great.
Court calls the case people versus Jordan Briggs.
Thank you, Your Honor. Go ahead. Janan Hamoud appearing with and on behalf of Mr. Briggs. Mr. Briggs, can you state your name for the record?
How are you, Your Honor? Jordan Briggs.
Thank you. So what are we doing?
Your Honor, Mr. Briggs would like to set this case for preliminary examination.
Let's cover the plea.
Yes, Your Honor.
Would the people have their witnesses available the 20th?
That's fine, Your Honor.
preliminary examination in person, February 20th, 2024, 9 a.m. That is before Judge Burke.
Your Honor, Mr. Briggs would like me to address bond when the court is ready.
I'm always ready. Go ahead.
Everybody wants lower bond.
Mr. Briggs resides with his mom. He had just had a son, 5 months old. Son was born in September, and he is responsible for the half of the care. Son's mother is the co-defendant in this case, and she's not in custody. However, she works and has been relying on Mr. Briggs's mom to assist with childcare. Mr. Briggs has had the same job with J&J Landscaping for 4 years. If he was to be released, he could return to work, which is important in order to provide financial support for his son. From my understanding, during the investigation of this case, law enforcement approached Mr. Briggs and questioned him on a potential felony charge. He voluntarily went with law enforcement to clear that issue up because he believed it to be false. And after that voluntary, where did you go? What station was that? Ann Arbor, yeah. After he went to the Ann Arbor police station voluntarily, he was subsequently arrested. He is asking that the court consider his release on a GPS tether. He has a place to stay. The address is in Westland. It's local. It's his mom's. She's resided there for quite some time. He will return to court, and he has, been compliant in
The allegations are that he pulled a handgun on somebody.
That's correct, Your Honor. But he maintains he was not in possession of a handgun at any point in time, and that he had stuck his hand in his pocket. And the co-defendant in this case had been pinned down at the liquor store or the convenience store they were at by the liquor store owners, and was screaming for help. And so to get her freed, the story I'm proffering is that he simulated that, but he maintains he never had a gun, and that is what he will continue to maintain throughout this case. He is entitled to the presumption of innocence, and given the nature of the allegations, I believe that in order to protect the community, having him on a GPS tether with constant court supervision is sufficient. He has no weapons in his possession and will continue not to possess any weapons.
I'd ask the bond remain is currently set. We haven't examined in a very short amount of time. The defendant was on probation until September of last year, 2023, for a plea and leaving wage.
Motion for bond reduction is denied. Bond will continue. Court calls the case People versus Nishan Eagleson.
Inmate's like, what? What? I didn't get the bond.
Hello, Your Honor. Good morning.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Eggleston.
All right, what are we doing?
Your Honor, I'd be asking to adjourn the probable cause conference. Still hoping to work out a resolution on this matter, but Mr. Eggleston is now out of the hospital and out of residential treatment. And I think we need to address his bond so that he may start testing in Mount Pleasant where he resides.
So what are you looking for me to do with this hearing?
Adjourn the probable cause conference, Judge.
Without objection, probable cause conference, February 22nd, 2024, 9 a.m. As to, I'm presuming there's going to be no objection from the people that he can test where he's located.
That's correct.
All right, so you guys prepare an order and I'll sign off on it. I don't have a problem with that.
Thank you, Your Honor.
Bond will continue in this case. Thank you.
He wants to talk.
Your Honor. Does that order need to specify a specific location?
It should, but that it can also just indicate that he can test where he is with results to community corrections at a facility approved by community corrections.
Thank you, Your Honor.
Court calls the case People versus Thomas Belcher.
Good morning, Your Honor. Assistant Procedural People.
The court
Assistant
is
Public Defender
slowly
Jay
thinning
Bellinger on
out.
behalf of Mr. Belcher, who approaches.
Hey, Greeners, can you get us information on Bridget Williams?
Your name
See if she's on the docket here this morning. That's where we're sort of holding
Thomas
out for.
Ryan Belcher.
Your Honor, after speaking with the prosecutor and my client, we are going to be asking to refer for competency. We have submitted the paperwork to the court for its approval.
Right. Forensic evaluation is ordered. Set a competency hearing in this matter. Should be 60, but they're not going to have it ready for it. Go ahead.
April 4th.
So April 4th.
Set it for April 4th, 2024, 9 a.m.
Right. Hang
Bond will continue.
Thank you, Your Honor.
Proposed case, People versus Jaquavius Carroll.
It is
Mr. Sinatra,
Bridget
Senior
Williams,
Assistant
right?
Prosecuting Attorney for the People.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Carroll. Mr. Carroll, will you please state your name, please?
Please, Carol. Thank you.
Your Honor, today's date and time set for an adjourned probable cause conference. We're asking for one additional adjournment. Mr. Carroll does have sentencing set in his federal case for February 26th, so we would ask for a probable cause date after that.
It's the 29th, right? Without objection, probable cause conference, February 29th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case, People versus Marnix Brown.
What county is Judge Simpson in? What court is this? Somebody, I can't remember off the top of my head. Is it right here? 14A.
You guys are on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown. Mr. Brown, will you please state your name for the record?
Marnix Brown. Okay. What are we doing?
Your Honor, at this time, we're asking that this matter be set for preliminary exam. My client does not wish to waive the 21-day time frame.
Is discovery complete?
Yes, Your Honor.
Not waiving speedy trial. Means it has to go fast.
People have their witnesses available. People have their witnesses available this Tuesday or next Tuesday?
Don't think we could do it this Tuesday, but
The following Tuesday?
Yes.
All right. Preliminary examination in person will be set February 20th, 2024. 9 a.m. before Judge. It's me. Okay, that's before me. Court as to any waiver in the timelines would find that the court, that there's good cause to do so given the schedule. Thank you. Court calls the case, People versus DeQuayne Delane.
Kenneth Overwater, Assistant Public on behalf of Mr. Delane.
What are we doing?
I'm asked to adjourn the probable cause conference. I don't have discovery yet in the system, but our file was just opened this morning, so that may be something on our end.
Probable cause conference, February 22nd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Okay, we're still waiting on Bridget.
You're not ready. Court calls the case of the People versus Jordan Earl.
Jim Sinatra, Senior Assistant Prosecuting Attorney for the People.
Your Honor, Lord Gaines, Senior Assistant Public Defender represents Mr. Earl. Your Honor, may we approach briefly, please?
While they approach, let me just tell you a little bit about Bridget's case that we expect here in just a minute. She's charged with, and this is a schedule for probable cause conference, so it could be very quick. It could get an adjournment, or it could be very interesting. She's charged with motor vehicle unlawful driving away of auto. We believe it was a police car that she unlawfully drove away in, which is always interesting. So we're gonna see if we can just get a peek into this case a little bit.
All right, I'll pass that matter. Court does call the case of the People versus Toby Bryant. Yeah.
Sean, thank you for the super chat. Press the like button. Please. It's free.
Hold on. You're not ready yet. Oh, he's right there.
New York Mom, by the way, thank you for that membership message. Congratulations on your second
Assistant
month at
Public
the Blue
Defender
Courthouse.
Appleton on behalf of Mr. Bryant, who's approaching now.
It's approaching slowly.
Mr. Bryant, will you please state your name for the record?
Lord Bryant. This is going to be a waiver.
Yes, Your Honor.
Mr. Bryant, I'm informed you're going to be waiving your right to a preliminary examination.
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on all 6 counts. Yes, sir. Yes, sir.
Thank you, Your Honor. We acknowledge receipt of the information. My client would waive any reading of the complaint, stand mute.
Defendant name and waive formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
February 21st at
Pre-trial.
1:30 before Judge Conlon.
February 21st, 2024, 1:30 before Judge Conlon.
Thank you.
Bond continued. Thank you. Court calls case People versus Christy Floyd.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Floyd. Would you state your name, ma'am?
Christy Floyd.
Your Honor, Ms. Floyd, at this time, there are no offers. We are requesting a preliminary examination.
Discovery complete.
That is my understanding, yes.
No offers.
People have their
Mean
witnesses available the 20th.
prosecution is not giving her a plea deal.
Any objection?
Any objection? No, Your Honor.
Preliminary examination will be set in person February 27th, 2024.
Stolen
9
police car.
a.m. That is before Judge Barr.
Thank you.
Bond continued. Thank you. Court calls the case of the People versus Portia. Is it Elledge?
Assistant Public Defender Selena Anderson with the Ms. Ellis is approaching. We submitted a plea form. This will be a plea for misdemeanor use with no objection to 7411.
That's the court's understanding of the agreement. Is that a correct?
Correct, Your Honor. Thank you.
May I have her sworn, please?
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help me God.
Yes.
State your name.
My name is Portia Elledge.
Ma'am, it is this court's understanding that you're going
Such
to
a
be
low voice.
pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes.
Ma'am, I also have to apprise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, ma'am?
Yes.
You understand you're giving up your right to appeal over it.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On August 17th, 2022, at the location of Holmes Road near Sweet Road, Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Counsel, have I complied with the court rule?
Honor.
People are saying.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
7th at 10 a.m. before Judge Washington.
March 7th, 2024, at 9 a.m.
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor. And may I address our bond, please?
May counsel approach.
Yes.
I have children. I have children. I'm sorry.
Ma'am, shh. I have 2 warrants. Ma'am, this isn't helping. This isn't helping. Yeah, if she's got 2 warrants out right now, she probably won't get bond reduced. Little bench conference right now. We are going to take a little break. If the judge takes a break, I'm going to read a document to you that I am very interested in. It's out of California, or excuse me, out of Colorado, that an order that came out just the other day regarding what I think is a fairly high-profile case, and it's not a nice order. This is open. Court's open to the public. Yes, it's open to the public. She also has trespass and gave false information to the police officer pending. Yeah, don't talk to the judge. If you got representation, let your lawyer talk to the judge. Only answer the questions the judge puts to you, and don't embellish. And usually that's just state your name, and that's all you need. I would even say you're all right not saying thank you at the end. Just let the lawyer handle it. You a good car chase. Oh man, what a feeling. I just reached for my water and the bottle's gone. I drank it all. Okay, so while they're working on that, we'll keep listening. But let's see if I can bring up the document I want to read to you. They'll be back in just a second, probably before I can get this document pulled up. Thank you. Appreciate that. Okay. This is from the 18th Judicial District Attorney's Office. Arapahoe County Judge Eric White issues this order regarding the trial of ex-Greenwood Village police officer Adam Holen. I think he's charged with in the death of a teenager. And let me see if I can get this to a screen where I can show you this as well. Tish, that's a great typo in that last message in Mod Chat, just for your information. When you see it, you'll see it. Okay, judge is back. Hang on one second. Oh, nope, he's not. Still sidebar. Okay, send that one. And this one. Okay. All right. Let me see if I can get the documents pulled up here. Why did it not show up? While I struggle to get this pulled up on my screen, I'm going to let you watch the debt clock for just a minute here. Hold on one second. We've still got Judge Simpson, Cedric Simpson, ready to go. So as soon as he comes back, you'll hear that audio as well. So just give me a second. Go through a different computer. How about that? Oh, that's why I was pulling up on a link instead of that. Okay, we're good. We're good. I got it. Where's my website? Hang on, guys. We'll get here. All right. Okay, we're I was gonna say we're back, but we're gonna go with the court for just a second.
I've been in the hospital. I've been in all kind of stuff. I was incarcerated in another jail. I was in Wayne County Jail. That's why I didn't come back the first time. That's where that one got.
Okay, and the court's question was that there was a warrant that was issued for the defendant's failure to, she had a PR initially on this case. She didn't appear in April of 2023. She's not arraigned again by us until February of 2024. And my question was, where was she? And then I'm going to have a follow-up question.
Okay. Yes, Your Honor. So in April, there is some notes that she contacted our office that she had COVID and wasn't able to appear. It looks like that's the date that the warrant was issued. She indicates to me that she was in the hospital some time and she was in a car accident and also in custody in the Wayne County Jail. Do you remember the dates or how long you were in Wayne County?
I was in there 45 days.
How did she come back into custody?
I was in a car. I was in a car with someone and they was driving a stolen vehicle.
So you didn't turn yourself in? Oops. Even after all that time. Motion for bond reduction denied. Bond will continue.
I didn't, honestly, it was all that time went past. I honestly forgot, Your Honor, about this charge. I would come. I don't mind coming to court for it. That's why I'm pleading guilty for it.
Take it up with Judge Washington. My decision is bond denied.
Thank you.
Why would you sit there and have me plead guilty?
You still gonna get the
I got all these other court dates. My baby birthday is on the 20th. Why would you tell me I was getting out of here?
You were getting out. I told you the judge had to make that decision.
I'm sorry, guys. My baby about to be 2 years old and you playing with me like that, bro. Keep playing with me.
Oh.
Come on here, bro. You don't let my friend leave it away. No. I'm not miss my birthday.
Why would you have me plead guilty? You told me I'd be out of here.
Don't touch me. Don't touch me.
She should have appeared.
Court calls the case, People versus Brent Graves.
Yeah, ready in this matter. Did I mention how nice your shirt looks?
Yeah, he's trying to just butter up the judge.
All around it.
Yeah, the last one that mentioned that was Miss Anderson, and you saw what just happened, right? Go ahead.
Well, my client thinks your shirt looks nice too.
Okay. All right.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf.
I like these
Graves.
Yeah. You're kind of red. It'd be a Wizard of Oz thing. Go ahead.
Anyway, Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for a preliminary examination at the first available date.
Discovery is ready?
Yes.
Or set?
Yes.
People have their witnesses available the 20th? Preliminary examination will be in person February 20th, 2024, 9 a.m. before Judge Burke.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. Court calls the case of the People versus Deja Foster.
We're hoping that Bridget goes soon because we've got a bunch of other stuff we want to do. There's some other courts to watch. Obviously, Judge Boyd is active
We're
again
ready in
today.
this matter, Your Honor. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Foster. Ms. Foster, could you state your name for the record, please?
Deja Foster.
Your Honor, today is the date and time set for a competency review hearing. You do not have an updated report. Does the court have an updated report?
I do not. So I don't have a report. And what I will do and what I've stated is that they're behind. So I'll kick it out 30 days. And if we get it, we'll reset it. Set this to March 7th, 2024, 9 a.m.
I think the previous lady did have a drug charge.
Continue. Thank you.
She didn't show up. She had warrants. She didn't turn herself in. She claimed she had COVID when she was supposed to be there. And
Court calls case
they
of the
caught
People
her in a
versus
stolen
Joshua
car
Hopkins.
as a passenger. So it's a series of bad choices.
Andrew Childers appearing on behalf of the people.
Public Defender Kalina Anderson with and on behalf of Mr. Hopkins, who's approaching. Your Honor, I still like your shirt despite my motion.
Everyone's trying this.
My fashion police duties never end.
Yeah.
Your Honor, Mr.
Your
Hopkins.
name, sir? Joshua Hopkins. Thank you.
Mr. Hopkins has been offered a misdemeanor, Your Honor. We're still taking some time to think about that. I've given him a copy of the report to review. It's my understanding the offer will remain open and we'd ask for a brief adjournment of the PCC.
Probable cause conference, February 29th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Stop at the
Thank you,
front
Jim.
counter.
Court calls case People versus Chavantes, I think, Freeman.
People.
Public Defender Jay Bellinger appearing on behalf of Mr. Freeman, who stands to my right. Mr. Freeman, can you please state your name for the record?
What are you doing?
Your Honor, we're just asking for a couple of weeks adjournment to see whether Mr. Freeman's going to be extradited to Nebraska.
Nebraska?
For what? That's correct.
All right.
Why do they want him?
February 22nd, 2024, 9 a.m. Bond continued.
Thank you very much.
Thank you.
Awesome.
Case People versus Jessica Huffman.
Andrew Childers appearing on behalf of the people.
Overwater Assistant Public Defender on behalf of Ms. Huffman.
Your name, ma'am?
Jessica Huffman.
Thank you.
Your Honor, we referred Ms. Huffman to 14B Recovery Court. I have not heard back on the status of the application. I did email Mr. Reyes about that, but I have not received a response. I'd ask to adjourn the probable cause conference.
Has she been interviewed as of yet or no? Probable cause conference, February 29th, 2024, 9 a.m. Bond continued.
February
Thank you, Your Honor.
29th.
Thank you.
That is a Thursday.
Court calls the case People versus Jason Garrett.
Andrew Childers appearing on behalf of the people.
Happens to be the date I got engaged. February 29th.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Garrett. You're going to be asking to adjourn the probable cause conference. I'd ask February 29th.
Means I only have to remember the date every 4 years.
Probable cause conference, February 29th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
But I guess this is the year I have
Court
to
calls the case People versus Matthew Kroger.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Kroger.
Your name, sir? Thank you, sir.
Your Honor, we've adjourned this matter a couple times. We've been waiting on discovery from Milan PD. I don't know if I know the prosecutor had reached out. I don't know if Mr. Childers has received anything.
Motion to dismiss. If the police can't produce the evidence.
With the officer in charge who said that it was being sent over, I will have to do a little bit of digging on my end, see where it is, because it's not showing up in our system. So,
But you got communication that something,
I did have communication with the other agencies. He contacted Mylan and received the reports, and they're being pushed to our office, but I don't see it yet. So.
Okay.
I think short should achieve this.
February 22nd, 2024, 9 a.m.
If the stream goes down suddenly, you'll know what happened.
I'll note that, there's a discovery issue, but
you can't whistle the Jeopardy theme.
All right. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the People versus Susan Hall.
We're running out of people in the courtroom, so I'm hoping we get this case for Bridges.
Assistant Public Defender Jay Bellinger on behalf of Ms. Hall, who approaches and stands to my right. Ms. Hall, will you state your name for the record, please? And Your Honor, we are just looking for a preliminary examination date.
Discovery complete.
Yes.
People have their witnesses the 20th.
That's fine.
It's 2:20.
Preliminary examination in person will be set February 20th, 2024, 9 a.m. That is before me.
Okay, so we'll be right back here. Thank you very much.
Thank you, Bob.
Take Missouri on anniversary date fund.
Court calls case of the People versus Tammy Lowe.
Prosecuting attorney for the
Morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Could you state your name, ma'am, please? Tammy Lowe. Your Honor, we are asking for an adjournment so that we can do a mitigation letter. We have 3 to 4 weeks for that, please.
Takes that long to do a letter? Never mind, Miss Gaines.
Thank you.
Defendant's like,
Probable
crap.
cause conference.
My lawyer got me in trouble.
2024, 9 a.m. Bond continued.
Thank you. And that was the 27th, Your Honor, or the 22nd? I don't know.
Cass Sass just got a call from the speech pathologist at my kiddo's middle school. We're getting to remove it from his IEP.
I gave you 4 weeks.
That's awesome.
So if today is the 8th, the
There's some-
22nd wouldn't be.
No, it would not, but I apologize. I'll ask Ms. Sweetman.
But they do write good letters when they come to us.
Oh, okay. Well, so it'll take a minute. March 7th.
Thank you.
Thank you, ma'am. Take care. Boy, oh boy, Gaines. Getting like brown.
This is not my week. It's been one of those days. It's been a
Court calls the case, People versus Carl Hearns.
Welcome, Debbie. Great to have you here. Hope you're having a fabulous day.
First Assistant Public Defender Tina Anderson with on behalf of Mr. Hearns.
State your name. Carl Hearns. Thank you.
Your Honor, in this matter, I filed a referral to our investigative unit. I've had a chance to speak with Mr. Hearns regarding that. He wishes to set a preliminary exam. He would ask for the next available date. I did explain to him that our investigators may need some additional time, but his request is to not waive any time periods and to set this matter as soon as possible.
I just want to address him on that because of everything else.
We're going to get to that. He's going to have to give you a court date. There's a copy of the report.
Thank you, ma'am.
Discovery is complete.
We received everything from the prosecutors, Your Honor. We are going to do some additional investigations.
All right. People have their witnesses available on the 20th. I mean, I can go on the 13th, but
I'm here for the Take Missouri on a date fund. Thank you, Kimar. Appreciate that. Thanks for the super
to
chat.
that day. set preliminary examination, February 20th, 2024.
Vicky, which way do I need to start earlier or start later?
And Your Honor, my client is asking.
At 9 a.m.
Oh, I'm sorry, Your Honor. My client is asking for me to.
Before, you just want to interrupt me.
Oh, I'm sorry, Judge.
Before
There's a lot of
Judge.
talking happening.
Yeah, I know. Before Judge Burke, I'm going to start calling it myself.
Adam, I had 4 years to save up for this date.
As to
for
bond.
sure. How long are you stuck with your brackets on your name, Adam?
As to bond, my client is asking that I address bond in this matter. We do understand the seriousness of the offense. Obviously, my client is maintaining his innocence and wants to proceed with us with some additional investigation on the case. He is concerned about losing his employment. He's an over-the-road truck driver.
I work for Recycle Ann Arbor.
Oh, he says he now works for Recycle Ann Arbor. He's afraid of losing his home and his property if he remains in custody. Right now, I believe the bond is $15,000. That's a bond that he cannot post.
I don't even know how it got set that low on 2 life offenses.
We had that
But you can-
discussion as well, Your Honor.
Yes, so you can go ahead and make your argument,
Yes.
but
It's not.
I will stop there.
I will be inclined if the prosecutor so asks to raise his bond, but you may continue if you wish.
Okay, Your Honor,
Stop
we did
talking.
have this discussion. He wanted me to make the argument, given Your Honor's position. He's asking that I
Well, I
withdraw
haven't stated a
that.
position yet, but
Well, we see where it's headed, Your Honor.
I'll let it
We're
be.
reading the room, Judge.
Yeah, I let it be. So,
so you're withdrawing your bond motion?
yeah.
We are, Your Honor.
Okay, bond will continue. Thank you.
Just.
Oh, okay, now we have it from the other side, so I'll address it. Hold on, sit
Okay.
tight. Go ahead, Ms. Willingberg.
Yeah, I just confirm, is there a no contact order in place and who was included in that no contact order?
What? I couldn't hear what she said. The
I
state-
have 2 individuals, a Hendricks and a Gilmore.
Okay. Yeah, Your Honor, in speaking with, the victim in this case was Leilani Gilmore and her mother is Ms. Hendricks. And speaking with Ms. Hendricks, did call her from the Washtenaw County Jail. And I did find that call. It was made from a different inmate's PIN. But he did communicate with her, was asking her to help them out of jail. But I want to ensure that he is aware of that no contact order, that it includes both Ms. Gilmore and Ms. Hendricks. Certainly don't want any adjustment to any lowering of his bond. But that we'll find his calls no matter what PIN he uses.
Understood.
Understood. I didn't understand.
Just you understand.
Just
All
don't
right.
say anything. Don't
Thank
say
you.
anything.
Thank you.
Don't say you didn't do it. Okay, so that was interesting. He tried to lower his bond, and then the prosecutor's like, "By the way,
Those case, People versus Jason Marchbanks.
by the way, he called a witness using somebody else's PIN.
And public
Tried to
defender
intimidate the
Jason
witness.
Mr. Marchbanks, who
Not good.
stands to my right. Mr. Marchbanks, can you please state your name for the record?
Jason Marchbanks.
Your Honor, we are asking to set this for a preliminary examination.
Discovery complete.
I would have to defer to Ms. Reiser on that. As I know, last time we were,
We have the guardianship paperwork. We're just looking for the
Katie, I
medical
didn't
records,
see
and
it.
I think that the council before the exam set for the.
and for what it's worth, Your Honor, we would be satisfied with that.
It didn't pop on my ends for some reason.
People would have their witnesses available the 20th.
I'm sorry if I missed it.
No, it's a defendant's out of custody. We could ask for something after the 20th.
It's not on the list.
Any objection to that, counsel?
No objection, Your Honor.
But you're waiting on medical records to try to get to them, and that might be a delay in that, correct?
Yes, that'll give us more time to make sure that council has us prior to the exam.
Without objection, preliminary examination in person, March 5th, 2024, 9 a.m. before Judge Perry. Okay. Thank you. Thanks, Judge. Court calls case of the People versus Mason Hurst.
Let's see.
Ready in that matter, Honor.
Pirate Museum.
Michigan Ashford, Senior Assistant Prosecuting Attorney for the People.
Vaughn Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hurst. Mr. Hurst, state your name for the record, please.
Mason Hurst, Jim. You're requesting a forensic evaluation.
We are, Your Honor. Based on my interview with my client, we believe that that is appropriate.
Interesting
Forensic
hairstyle.
evaluation is ordered. I sign the
into the
order.
courtroom.
Set a competency hearing April 4th, 2024. 9 a.m. Bond continued.
If you're going to Beaufort, one of the great things you can do is to pay the fee to take the ferry out to the OBX, to the island, and check out go shelling out there. That's an amazing thing.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Morris. Mr. Morris, please state your name for the record.
James Morris.
I've seen Mr.
Your
Morris
Honor, today's
before.
date and time set for a probable cause conference. At this time, we're asking for a 2-week adjournment. We did receive the discovery yesterday as well as some video discovery this morning. So I'd like an opportunity to review that with my client.
February 22nd, 2024, 9 a.m. Bond will continue.
Thank you.
Thank you.
Uttering and publishing counterfeit bills or notes. Those are the charges.
Recalls case People versus Jordan Earl.
Michigan Ashford, Senior Assistant Prosecuting Attorney for the People.
Joy Gaines, Senior Assistant Public Defender. Earl, please state your name, please, sir, when you get to the podium.
Jordan Earl.
Your Honor,
Hands out of pockets, judges.
Our office has
Hands out
been
of
in some discussions with Mr. Ganatra. It's my understanding that he is going to reach out to his officers to see if we can have a misdemeanor resolution, and we are asking for an adjournment for him to do that.
Probable cause conference February 29th, 2024, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls the cases of the People versus Charles House.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
4 cases.
Who's the defense?
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. House.
Wait, what are we doing?
Your Honor, we are doing a waiver of preliminary examination on all 4 matters today. I do have the waiver form here in front of Mr. House so that he can sign it.
Long delay.
Mr. House, is that correct, sir, that you're waiving preliminary examination in all of these matters?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand that you'll not have that hearing on any of these and you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over on all 6 counts.
I'm sorry.
Your Honor, if I may, there has been an offer that has been extended. It will
Yes.
stay open to the court. Can I put that on record?
Yes, you may.
The offer that has been extended is for the defendant to plead as charged in case 23F21262. We would be dismissing 23F55180 as well as 23F55181. And then in case 23F55179, the defendant would be pleading to count 3. Counts 1 and 2 would be dismissed. Additionally, this would be with no habitual.
That's correct, Your Honor.
All right. And if you didn't say so, the people do waive the right.
Yes, Your Honor.
All right. Preliminary examination having been waived, defendant is bound over to circuit court. Ms. Gaines.
Ricky
Your
C,
Honor, we
congrats on
acknowledge
6
receipt of the
months.
information, waive its reading on the record. At this time, my client wishes to stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial will be set for
At 1:30 before Judge Conlon.
February 21st, 2024, 1:30, Judge Conlon. Bond on all of these matters will continue.
May I approach to send the information?
Yeah, give me. I just want to make sure I got all this work right. Good.
Court is getting very empty, so we don't have many people left. Let's see who it is. Hopefully we can get Bridget in here soon.
All I have left are in custody in any event, so we'll be a little bit delayed, but.
What? Imagine Bridget is in custody. Boyd is live today. I can let me see. I want to see if he's going to take a break. I can see what she's doing here.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth?
Yeah, so we've got Judge Boyd to go to in just a second, but something in the middle as well.
Court does call the case of the people versus Michael Conesco.
Horrible, I'm right on behalf of the people.
First Assistant Public Defender Clinton Anderson with the attachments. State your name, Mr. Panessa. Your Honor, 30-day requests for adjournments are not going so well, so I will ask for 29 days if possible. I filed a referral to our investigative unit. They're going to follow up with Mr. Conesco, and we need the time to do so.
She's trying to make, I'm not going to have a bad day because
We're waiting on Bridget
Williams.
Williams.
Conference adjourned March 7th, 2024.
We'll come talk to you before then, okay?
Okay, fine.
Your Honor.
That's it.
That's it. Thank you.
All right. Thank you.
She just full on interrupted him talking to her client saying, I'm going to come talk to you before then. She got what she wanted. So stand mute means not going to reply, not going to enter a plea. And the court enters a not guilty plea on your behalf.
Okay. All right. So on the House matter, I have 3 of the informations. 1 of the information are not in the file, so you can sign those 3. But
There.
Court does call the case People versus Robert Lewis.
We're ready in this matter, Your Honor.
Prosecuting Attorney Morgan Barroso on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Robert Lewis. Mr. Lewis, could you state your name for the record, please?
Robert Lewis. Thank you, sir.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting to have this matter set preliminary and at the appropriate time to address the bond.
Everybody wants
Discovery complete.
As far as we know, Your Honor, yes.
People have their witnesses available the 20th.
Yes, ma'am.
20th is going to be
Preliminary
big trial
examination
day.
will be set in person February 20th, 2024, 9 a.m. That will be before me.
Thank you, Your Honor.
Judge
May we
Simpson's
address the
amazing.
bond?
You may.
Your Honor, my client is currently being held, I believe it's what, $5,000 cash is the bond?
It's 50,000 cash.
50,000. Your Honor, my client would be asking for a 5,000 bond with 10% privilege. He is currently on disability. He does have a place to stay that will be away from the complaining witness in this matter. He is asking that he be allowed to continue so that he does not to be released. He wants to be able to maintain his disability. He will have no contact with the complaining witness in this matter. He maintains his innocence, and he believes that upon the court's hearing of this matter, he will be exonerated.
Response.
Everybody believes that they exonerated.
Give me one moment. Okay.
All right.
$50,000
I'm
is a
not going
lot.
to need a response. The indications, and I understand his presumption of innocence, but that he's the residence that was broken into, that there were children in that residence, and that the children, because of what was happening, were required to call 911. Motion for bond reduction denied.
Ooh.
Thank you.
The facts of the case are such that the judge says not inclined to give him a lower bond to get out. Usually they have to put 10% of the bond up. So if it's a $50,000, you'd have to put 5,000 up. If it's a 5,000, you have to put 500 up. And then usually there's a fee that goes to the bond company as well.
Court does call the case People State of Michigan versus Jeanette Monroe, and I'm going to tell you why later.
Commissioner, Senior Assistant Prosecuting Attorney for the people.
An Assistant Public Defender, Hannah Apple, appearing on behalf of Ms. Monroe. Ms. Monroe, will you please state your name for the record?
Jeanette Monroe.
Your Honor, I thank you for calling this matter early. I wasn't able to
Oh,
get it.
don't thank me. I said no. They did it. Go ahead.
Well, Your Honor, I wasn't able to get a hold of Ms. Monroe to inform her of her noon time block, so I appreciate that. But we are asking for an adjournment. She was referred for circuit court treatment court. And my understanding is that we should have a response regarding that on the 22nd of February. So I'd ask for an
You're
adjournment.
going to get a response on the 22nd.
That is the date of their meeting. Yes.
So you need a date after.
Yes.
Probable cause conference, February 29th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you.
You. Nice.
Court calls case People versus Jerrica Locklear.
Morgan Barroso.
Overwater Assistant Public Defender on behalf of Ms. Locklear.
I never met up with you.
I know, I tried to. Yeah, it's a date and time set for a probable cause conference. I made a couple attempts to meet with Ms. Locklear prior to today's date, and she was not made available. So I did not have an opportunity to speak to her. I'd asked to adjourn this matter 1 week. I did. Discovery came into our system today, so I did not have would not have had an opportunity to review it with her anyway.
February 15th, 2024, 9 a.m. Bond continued.
This is how Sarah Boone looks at her lawyer when the lawyer's like, I tried to reach her at the jail and I couldn't. And she's like, what was I doing? Where would I have been? Her face. Oh my goodness. I hate that argument.
Thank you.
I realize there are sometimes the jail, for whatever instance, there might be under lockdown or things like that. It can happen that an attorney goes to visit the client and they say, hey, we can't accommodate that request right now. It can happen. Generally, I think this is like a cop-out when the attorney's like, hey, I was busy. I tried, made a phone call, and my call got disconnected, so I tried. Yeah, I'm not buying that. I don't think that attorneys are struggling to get in to see clients, that the jail is that hard to work with across the country. But, man, the way that his client just gave him the stink eye.
Case of the People versus John Outcall.
Yeah, this is crazy.
Andrew Choate, during people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Outcall. Nope. Turn this down.
Wrong side.
What are we doing?
Yeah, I started adjourn this matter 1 week. I did speak to Mr. Childers about an offer. He had reached out to the officer in charge, but has not heard back.
Is he being held on anything else? Because these 1 week adjournments are going to kill my staff.
He's held on 5 other matters.
Probable cause conference, February 22nd, 2024, 9 a.m.
Thank you, Your Honor.
5 other matters.
Speaking of
Sarah Boone, tomorrow is the date we expect Sarah Boone's attorney to appear. before
Water
the
Assistant Public
judge
Defender on behalf of
asking
Mr.
to be
Bissonnette.
let off the case. So we're going to keep a close eye on Sarah Boone's case tomorrow, because that could definitely impact the schedule for her trial, which was currently set for early March, I believe, or May. It's one of the months that starts with M. I've got to look at my calendar to tell you. Let's see, Sarah Boone. Where are you at, Sarah? There we go. Upcoming.
Personette.
I need to refresh this one.
Personette, state your name for the record, please.
Matthew Personette.
All right.
It's time and date for a probable cause conference. I believe at this time discovery is complete. At least there's nothing I'm unaware of that I don't have. It has to set the matter for preliminary examination.
People have their witnesses available the 20th.
We will try.
Preliminary examination in person, February 20th, 2024, 9 a.m. before me.
YouTube doesn't
And
show
we'll
me
continue.
who likes
Thank
the
you.
videos, just
Thank
like
you,
it
Judge.
doesn't show who, like if I did like a, I guess this would be Amazon. If I did like an affiliate link to a product and somebody bought something, it doesn't show me who bought something. They don't give out that information. KBF says jails are notoriously hard to work with. Prisons are worse. There was one in Texas shut down for months. Couldn't even send or receive mail or calls. You're saying that I need to give the lawyers a little bit of slack. If they're pushing this off till the afternoon, we're going to bail on this and try to catch it on a replay. We've waited all morning for Bridget, Your Honor. Can we make that happen? KBF, thank you, by the way, for the super chat, and thanks for the information there.
Calls the case, People State of Michigan versus Christopher Shoemaker.
Shoemaker.
Mr. Canatra, Senior Assistant Prosecuting Attorney for the People.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Shoemaker. Mr. Shoemaker, will you please state your name for the record?
Shoemaker.
Shoemaker.
Thank you. Your Honor, we were asking for a brief adjournment. I need an additional opportunity to review the police report and information with my client.
Not guilty.
Yes, sir.
I love that.
Verbal argument.
Nope.
Well, I don't want you to say anything about the case. Probable cause conference, February 22nd, 2024, 9 a.m. Bond continued.
Thank you.
Thank you.
The lawyer's like, nope, remember how we talked about you not talking in front of the judge? Katie, I'm looking to see if what's happened here, and I don't. I am not seeing it. I'm not sure. I might be able to show you what. Let me show you my screen, Katia, just for a minute. This is what I can see. YouTube will show me all the gift messages and the anniversary messages and everything, all the super chats and super stickers. And I've been through the list here from the start of the stream, and yours is not showing up. I don't know.
Calls case of the People versus Delco Thomas.
So I do not see that for some reason.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Delco Thomas in 1522 and 5011.
And good morning, Your Honor. Sydney Rush, and appearing on behalf of Mr. Thomas, who appears to my right on 1596. And Mr. Thomas, can you please state your name for the record?
Delco Thomas.
Thank you.
What are we doing?
Your Honor, today is the date and time set for the probable cause conference. My client is respectfully requesting that his matters be set for preliminary examination. Bless you.
Bless you.
And mine as well, Your Honor. So all three.
Discovery is complete on all of these matters.
To the best of our knowledge, yes, Your Honor.
Yes, Your Honor.
People would have their witnesses available the 20th.
Your Honor, given the number of cases involved, that's possible.
Any objection?
And my client is requesting the earliest date possible.
The state's having trouble getting the witnesses on the 20th. If they can't bring a witness, the case gets dismissed.
Then if that's the case, Mr. Ganache, at least have somebody here to start something. And then
We can start with one, and if we don't have everybody available, we'll ask for a continuance.
understood. Preliminary examination in person will be set February 20th, 2024. 9 a.m.
This super
That is
chat
before
from
Judge
Thomas,
Burke.
my podcast partner. Yesterday, when I had to go to the bank,
Thank you, Honor.
Thank you so much,
I was
Your Honor.
sitting
My
there
client
for
has one further request of the court.
what?
Instead of including a new closest date, go ahead.
All he is asking is that he be allowed release to treatment. He's making those efforts in another case. He believes that they will allow him to be released. It has
Say again.
Release to treatment to Sacred Heart. He's making those arrangements in his other cases. He'd like to have a similar bond condition here. As the court can see from the nature of the charges, it's an issue.
Correct.
Yes, and I don't have a problem with that, but prior to the exam date, I'm not going to change the bond condition, not let Judge Burke deal with that.
All right.
Thank you.
Thank you, Your Honor.
All right.
So yesterday, while I was at the bank, the meeting took forever. It was like an hour and a half of sitting there watching somebody type. And during that, I posted a picture because my chair, because the four business people, the four people in our company for the Airbnb, were all in the office, and I was stuck in the corner behind the monitor, so I couldn't see. I was just looking at the back of somebody's screens, and I sent a picture saying, "This is my view," and Weatherwatch made a bet. He said, "I'll pay you $5 if you can work cable management into your conversation." So I pulled out my phone and I started recording. And I asked a question about cable management for the monitors that were in front of my face. So he's paying up on that bet there. It was an easy one for me. I can talk about cables all day long, Weatherwatch. Thank you very much, my friend. Look forward to the podcast tonight as well.
Case of people
is it
versus
Eris?
Patrick Thorne.
Woke up sick this morning, missing work today. My plan is to listen to you all day. Well, I sleep on and off.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Thorns. Mr. Thorns. Mr. Thorns, state your name for the record, please.
Patrick Thorne.
It's the date and time set for a probable cause conference. Looks like an exam date is already set for the 20th before Your Honor. We would ask to continue to that date.
Zena, I'm sorry you're sick.
Yes, we did.
Thank you for 3 months of support. Hopefully today is...
Continue to preliminary examination.
You get more rest and less listening. You get feeling better tomorrow.
9 a.m. before.
We are going to be live tomorrow. Yes, we definitely are. Thank you very
Aaron.
much for the question. Sarah Boone is one of the things that we're definitely going to be interested in tomorrow before our court case that we anticipate starting on Monday with the texting judge. We've got our fingers crossed. The information's a little bit sketchy out there right now, but if it happens, we will be there for that. Evie, yes.
This is what jail one.
Greener says, "You're a good man. Throw it in the YouTube cut." Thank you, Thomas.
It's supposed to be at 11.
Oh, okay.
What was that? Did they say Bridget? I was talking. Did they say Bridget? Greeners, where can we send it?
Case Other People versus Bridget Williams.
Here it is. This is it. This is Bridget. Please don't extend. We want this to go. We want the full, I won't say full Monty, but we want the whole thing right here. I said full Monty.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Williams.
Sit back for just one moment. I need to do something.
Judges, this is the case we've waited for. The charges, the charges in this case are, let's see, we've got unlawful driving away of an auto. The auto happened to be, I believe, a police car, and she took it about 45 miles, which I guess you're not supposed to do unless you're actually a police officer. So that's where the charges came from here. So we're going to see, hopefully this moves forward, not just another adjournment. It could just be a 29-day adjournment here as well. The charges against the texting judge, oh my goodness, I'll have to go into those. That's let's see. Last name. Let's see. That's a texting judge is it in Kansas or Oklahoma? Somebody refresh my memory here. Podcast tonight is a definite yes, Miss Kevin. Scroll up for my scheduling details, please, Vicky. Let me look and see what we've got. So you go live at about 3:45. 5, so you can adjust accordingly.
My apologies. All right.
What? What was that? What did they do? They did something, didn't they? Yes, they did. Why are you covering for people? Never mind. We'll talk. All right.
The bailiff's like, I'm not, just keep me out of this.
And he took my candy. Anyway, we're back on the record in the Williams matter.
Your Honor, we had requested some additional discovery. Mr. Childers indicated that he received that discovery last night, so we're hoping to have a chance to look at the video and are requesting an adjournment to be able to do so.
Probable cause conference, February 22nd, 2023, 4.
The video
9 a.m.
Maybe dash cam video.
Bond will continue.
February 20, what was the date? I do an awful job. Do you guys catch the date of when that's happening? That was the one we were waiting for, and it got pushed out.
That's all I have right now.
There's going to be a dash cam video. February 22. Thank you. Let's put this on the schedule here.
So I have 2 defendants still left, but they're not on. We're waiting on the jail.
Yes.
All right. Then court will stand in recess.
All right.
Okay, so while they're in recess, we're gonna prep some things. That's February 22, sorry. Okay. And that is Cedric Simpson. Okay. All right, we'll get that updated. All right, so that was a big letdown. I apologize for that, but apparently, if we can get that video, that would be fantastic. It would be police video. We may, you know what? Because it's a police dash cam, we might be able to do a FOIA request and get that. Because what could happen is once they get the video, it might be like a no-brainer. It might like show her stealing the car and yelling and swearing and driving around. That she might plead guilty. So that might be something we look to do a FOIA request on, see if we can get the video from the police directly. Let's see. Miss Violet says, who owns the internet today? We have a couple packages that need a rush for today. I have a package I have to pick up at the post office today, so I'll have to go get that as well. I got notice that was there. Who took my candy? That's a soundbite, says Kiki. Please. The judge says somebody took my candy, and the bailiff was refusing to narc on anybody. So, okay, let's do this. Let me bring up this document, and before I let's see, can you guys even see that? Is it too tiny? It just looks like a blur, right? Let's see if we can zoom in. Zoom works. Zoom works. We're going to be good. Before we begin this document, let me tell you. I found this on Twitter. Obviously, this was posted by 18th. Let's see. Let me get the posting right here. 18th Judicial District Attorney's Office on Twitter. It's DA 18th is their handle. And this is out of Arapahoe County Judge Eric White. This is in Colorado. Issued this order regarding the trial of ex-Greenwood Village police officer Adam Holland. And I'm going to read this order to you. And I will tell you right now that I do not like it. I do not like this order. Let's see. The court Having considered CRS as well as Chief Justice Directive, hereby sua sponte, I don't know what that is, I'm terrible at Latin, finds there to be reasonable likelihood that remote observation of this proceeding, which is the trial, risks compromising the safety of any person, the defendant's right to a fair trial, and or the victim's rights for the following reasons. So remote view. This is not broadcast. This is having a Zoom feed, having a Zoom webinar, WebEx, broadcast, the news media, anything else. It's all covered under here. So he says, doing that risks compromising the safety of any person, the defendant's right to a fair trial, and or the victim's rights for the following reasons. 1, Chief Justice Directive recognized some of the issues attendant to the live streaming of criminal proceedings, to include witness sequestration violations, victim protection obligations, and defendant's rights protection. In recognition of these important considerations, the directive excluded presumptive live streaming of evidentiary hearings, trials, bench conferences, and attorney-client communications. With this guidance in mind, the court now considers the legislative pronouncement on live streaming as applied to the matter at bar. The proceeding at issue here is a jury trial, wherein the jury will hear witness testimony offered by the people and perhaps by the defendant. At the proceeding, the witnesses are subject to an entry of a sequestration order, which has entered at the request of party per the rule. So sequestration, that's when they say if you're a witness, you can't be in the courtroom and you can't listen to other people's testimony. So they say that's going to happen. The sides have already asked for the rule to be invoked. Sua sponte is the judge doing something on their own with no request from either party, which makes this worse. So as is the court's habit, it shall rely upon the attorneys to identify their respective witnesses, advise those witnesses. I don't like this so much, I'm allergic to it. I just had to sneeze. Sorry about that. Advise those witnesses on the order and bring to the court's attention those entering the physical courtroom who are subject to the order. That's always the attorney's responsibility, right? They have to tell the witnesses, hey, you can't be in the courtroom, or if somebody's in the courtroom, you say, sorry, judge, this witness is in the courtroom, and the bailiff will kick him out. Bringing to the court's attention those entering the physical courtroom who are subject to the order. Monitoring the public live stream creates challenges with that procedure insofar as the court and the attorneys will have to divide their attention between the proceeding itself and observers on the live stream. As the court and attorneys are distracted by monitoring live stream observers, the court may then be called upon to interrupt the proceeding to identify new observers and to advise them of the sequestration order. Indeed, remote observers may or may not utilize proper name tags to assist the court in identifying who they are and whether they are subject to the order. Of course, this speaks nothing of remote observers who deceive the court as their identity as a witness. You're saying we would have to stop court every time somebody joined Zoom and say, hey, who are you? Are you a witness? You can't be here if you're a witness. Okay. Let's see. What case are we reading about? It's only a case where a police officer is involved in the shooting death of a teenager. That's it. I don't see any need for any transparency at all on a case like that. Do you? The monitoring of live stream under these circumstances is not conducive to the orderly administration of justice. More importantly, remote observation of the proceeding in violation of the sequestration order jeopardizes the defendant's right to a fair trial. Remote observation of the proceeding in violation of the sequestration order jeopardizes the defendant's right to a fair trial. Do you know what else does? A witness walking into the courtroom. Is that going to happen? No. Is this going to happen? Probably not. So because of that, and it undermines the intent of such orders by allowing witnesses present by live stream to tailor their testimony to that of other witnesses. That concern is not present when the court and the attorneys can physically observe people entering the courtroom and identify, without significant disruption, whether they are subject to the sequestration order. Audio only and or selective disconnection of limitation of remote observation do not remedy the problem. Therefore, there shall be no remote observation of the proceedings for that reason. Further, the court is concerned about the live streaming I'm going to move me up into the top corner here. The live streaming of these proceedings for reasons of witness safety and juror privacy and safety. As to jurors, the public only has access to a list of prospective jurors' names. That is public. Information contained in juror questionnaires ordinarily must be held in confidence by the court, parties and counsel, and their agents. Although juror names and disclosures made during jury selection are exempt from that confidentiality limitation, the court discerns little reason, other than as voyeuristic consumers, that the public at large should be able to anonymously tap into a live stream and obtain private information generally intended to be only for use of the court, parties, and counsel. As to both jurors and witnesses, in criminal cases like the matter at bar, this anonymous remote observation heightens the court's concerns about safety. The court simply cannot effectively ascertain who is remotely observing the proceeding and what they are doing while watching. Well, I'm eating pizza, if that's of interest. There is no legitimate mechanism to prevent observers from audio and or video recording the live stream and utilizing that information to locate and attempt to influence and retaliate against jurors or witnesses. Any attempt to record the proceedings by a courtroom observer is observed and is subject to immediate court intervention. Further, law enforcement deterrent presence is available to monitor those in court and to ensure that the proceedings are not being recorded. No such option is available for live streaming. Audio only and selective disconnection. Sorry, I have to zoom out to get to the next page. There we go. Selective disconnection or limitation of remote observation do not remedy the problem. Therefore, there shall be no remote observation of the proceeding for that reason. 5. The constitutional right to a fair trial is implicated when a jury is exposed to extraneous information. Media reports have the potential to prejudice the defendant's right to a fair trial. As applied here, this matter has been subject of significant pretrial publicity, and the media has demonstrated its interest in reporting on the matter. Given the media's interest, live stream availability subjects the proceeding to practically boundless real-time media exposure throughout trial proceedings. The information, as may be reported by the press, is then available to jurors, particularly by unintentional internet pop-ups. Has this guy used the internet ever? Even when the jurors are not actively seeking the information. Therefore, there shall be no remote observation of the proceeding for that reason. Of course, the courtroom itself remains open to the press and the public during the trial proceedings, absent further order of the court. The absence of live streaming thus prejudices neither the press nor the public. There shall be no live streaming of the trial. This case, it has had none of those things happen. Zero things happen. We haven't had anybody who says they are trying to threaten a witness. We have not had any witnesses who said they're trying to be threatened. We don't have any potential jurors who said, hey, somebody's trying to out me and identify me. It has not caused a problem. They do not have to identify. They have to stop Zoom. By this same, the judge is saying he would have to find out everyone who is watching the live stream on the news by name and have to just figure out, well, great, now it's on the news. Clearly, our witnesses are all watching it. Every other court in the nation can figure this out. And this judge, by this ruling, has said, you know what? We are not going to allow any live streaming at all because something bad might happen. The distrust of the public, the distrust of the jurors that he swears to under oath, and the distrust of the attorneys to educate the witnesses and the witnesses themselves to follow the rules of court is just, he's basing his entire ruling on this. And it makes me just a wee bit frustrated. What I would like here with the people of the state of Colorado versus Adam Holen, case number 2021 CR 2843, is if everybody who has an interest in this trial informs the court they will be present. If everyone who has a website, a blog, a Facebook page that they update, a court observer page, a little channel like my own where they follow the news of court, informs the court that they would like to be present for this as a member of the press. And so the court knows how many hundreds of people would like to be in their little courtroom and how necessary it is to have a live stream. I would like that a lot. I don't know how to make that happen. But the fact that that we have a police officer charged with murder of a teenager and the shooting death of a teenager, I think this, of all cases, is one where we should have transparency, that we can see that the system works for the people on the inside, namely people in the legal profession as well, police officers, as well as the common citizen. If this were to happen behind closed doors, I think what the judge is inviting here by not allowing anyone to observe what happens, either audio, real time, delayed, anything else, unless you are physically there in court or wait until you get some sort of report, secondhand or third hand through somebody else, I think the speculation will be rampant. And if for some reason the outcome differs from what public opinion is, how can they think that this is a better outcome for justice than by live streaming this? I am so frustrated with this that anyway. This judge, he's not up for retention again until 2029. So he's got quite a while before he gets voted out. But I realize we don't go Pickles. We do Pickles, not politics here. But I would say issues like this, where we have a judge that is clearly circumventing the rules of the court and the advice of the legislature and the Chief Justice directive by making a finding that does not exist, and he does it. Let's see. What did he say? Sua sponte, without any side making an argument. He just on his own just thinks he's going to just shut things down. I think this is bad. This is bad judging. This is bad judging. Oh my goodness. Yeah. So this case involves an officer shooting a 17-year-old boy. Makes 100% sense why he's trying to keep it in the dark. But this is pushed by some police union arbitration. I don't know, because he says nobody has told him this. This is a decision he made on his own, which means neither side has brought any concerns up regarding this. And he's just going to shut it down so nobody can see. Is it legal? Unfortunately, yes. Can we change that? Yes. This is a trial that's supposed to run here very, very shortly. I think it starts next week, but very, very, very soon. But he's completely shut it down. So unless you are, and get this, and if you are a media member, guess what you don't get to have in the courtroom? You don't get to have any electronic devices. You literally have to be there with your pencil and your notebook, scribbling notes as fast as you can while you're wearing your little press hat, with the little paper tucked in saying your press. It's like straight from the 1920s. And he says that suffices. That suffices to make sure that the public's right and the press right is met. You got a handful of people in there and that's it. They're going to scribble something. Well, guess what? People don't get their news from the newspaper anymore. I'm sorry. It says newspaper, but very, very few people get their news that way. They get it through video. They get it through watching their phones. And I think having the courtroom open helps to educate the public about the legal system and instills trust in the legal system, which I think is paramount. Anyway, so I'm a little frustrated about that. I think it's a terrible idea. I think it would be appropriate for people to call the court and ask them if there will be options due to the high demand for attendance. I think people who want to attend should inform the court that they will be attending and how early in the morning they should be there and if they'll have secondary viewing rooms available for the crowds. If there's media pooling, because the number of media who want to be present exceed the amount of room that's in the courtroom. It's frustrating that the judge just throws this up, especially on a case like this. You guys, if this ends, and I don't have any argument, I don't have any opinion on whether the officer was in the right or the wrong. I don't have the facts on that. I wish I did because I wish I would watch it so we could find out what the facts were. We could watch it like the jury does. But if this ends with the officer being vindicated, there's going to be one side who is just screaming bloody murder, saying it wasn't fair. And if it ends with the officer being arrested, there's going to be another side screaming bloody murder that this wasn't fair. And the speculation, the argument about that will just be based on this public discussion of people who did not observe the trial and did not see the facts of the case. I think it's terrible. I think it's terrible. Anyway, that was my phone ringing in court. Sorry, Greeners. I apologize. I'll turn the ringer down. All right, that was my rant. I would suggest that nobody do anything that would hinder the process of the court. I have such respect for the court system, even when crappy things like this happen. But if you are interested in going to this trial, if it is something that you could adjust your schedule and attend, I would recommend that you do that. Oftentimes, the rights not exercised are the first ones that we lose, right? And the public's right to attend a trial, in this case, is the last thing that's been preserved. So a big push there to inform the court that there is a massive interest, and that is the reason why we have live streaming, and that making these presumptive findings without any evidence, sua sponte, however you say that, is just the wrong way to go. Anyway, there's my rant for today. Colorado via Adam Holland is the case. Yeah. All right. Deep breaths are important as you're no longer a spring chicken. We need some Zen music to. All I've got is the sad. I've got our podcast music. I've got the cat music. This'll work. I'm going to imagine myself on Brandy's beach, watching the sunset over the Gulf of Mexico. I wish. I don't know, Jenny, if he's done this on other trials, but this one is just seems terrible. It seems terrible. So, Brandy says no live streaming her beach. No, she's kicking me off the beach. It's a public beach. I imagine you on a horse, not on a beach, when I hear this music. Yeah, this is it's called Cat Searching. I don't know why this name's that. I don't think of cats when I think of this music, but that's deliverance music. All right. Courts need to modernize with the times. Mike, if I had my way, let me do just a quick rant on this, and then we'll move on to possibly Judge Boyd here in just a moment. If I had my way about this, I would say that legislation needs to be put in place, because the judges have to abide by legislation. And some states have done this right when it comes to media access. And Texas is one of them with Bexar County. They're just wide open. You show up to court bringing your camera. That's the first notice the court has. They're like, all right, just go ahead and set up in the back. Try not to hit too many people with your tripod. And they're good to go. I like that level of openness. Obviously, it can't be done all the time. And it does require some participation on the media's part, especially when we have cases with sensitive facts, sensitive witnesses. And I am all 100% in support of not showing like children when they're testifying on the stand. In the SA cases where the testimony is harmful and could really be embarrassing for victims. That should never be shown. The jury should never be shown. We're on the same page there, and I think the media can cooperate with courts to make sure that happens. But Adam Holden started yesterday. Was it in jury selection yesterday, so it starts today? Yeah, we don't know. Nobody knows it started, because guess what? It's not being live streamed. Anyway, I think the best thing to do is to contact your legislatures. And I'm not saying one party versus the other. I think every party needs to work together to fix this, because this isn't a party issue. But voters need to let people know that it's important to us that the system be transparent and that we know that it's working properly. And the best way to accomplish that is through transparency through media in the courtroom. Ivan Victor says, hope all is as well. Orange House, I've been lurking, just busy making enemies with the nearby school district. We all need hobbies. Ivan, I've been following that a little bit with your messages. You have lit a few fires, I think. Vicky, yes. I understand there are some cases where it is not appropriate. The pressure, the threats, if you're dealing with like mob situations where witnesses are scared to testify, there are situations where it doesn't always work, where it's not appropriate to have the media coverage. But even the cases that have some of those issues for whatever the reason, there are ways to still let the public hear, even if it's delayed. If there's audio only, it's just something so that there's a level of transparency with it. So there's somebody else that can check it and say, yeah, what happened there was okay. The system is working. Patty B, I saw some of that interview from the Crumbly trial. I was frustrated with the clinching bit of information, because the last bit of information that I heard that she was in possession of the firearm was that it was locked in a vehicle, and that's not the best place to put it, but it is locked in a vehicle. And the vehicle was not like smashed into to get it. It wasn't stolen from there. I don't know. Katia says, I've appealed the super chat issue. I'm sorry about this. Katia, I wish the system worked a little bit better. I don't know how to fix it either. Colorado judge's decision gaslights both sides. Public viewing calms both sides. Mickey, I'm on the same page here. I agree. All right, let's, since we're supposed to be having down days and I just raised my blood pressure to unhealthy levels, let's go ahead and jump in with Judge Boyd, who is always a relaxing destination.
State will be prepared to make an offer.
Yes, Your Honor.
Oops, let me turn the audio on. That's better.
All right, and then
Why is my audio off?
on your client,
I'm going to change the feed really quickly. Hang on.
you say Monica is on her way?
Randall? We have the same discovery thing, the translations that were transcribed.
So let's have him come down because it's going to be March 26th. All right.
Randall, come down.
This should be synced up a little bit better.
Yes, it's always great seeing you. You just brighten the day.
Oh, thank you. You're
Have a good one.
Me too.
Lee Galindo. All right, today is the plea deadline date.
Judge, wait for Mr. Clinton to get up here.
Sure.
Judge, Daniel and I are real close to a couple of things we just need to iron out. I was gonna ask for Monday, but apparently all are full.
Are you ironing out? Are you have the starch, the faultless starch?
We have a good foundation, Judge. We just need to finalize it. If Tuesday is still available, then.
I think Monday was too much for inmates, correct? So we can have you back on Monday.
Oh, Monday?
We have a big.
I'm sorry, what?
The doc is pretty, they can still put it on there. I already sent it out.
Okay.
Or Tuesday, Judge.
Well, we can put it on Tuesday. All right, 13th.
Yes, sir. Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you.
You're welcome.
He's gonna have to have it. And then we'll give it to him.
YouTube might be having some trouble here. Let me see what's happening here. A couple of people are reporting problems with super chats. It's not coming through on my side. I don't know
Who's here
what's
on
happening.
Andrew Arnett? Are you all ready? Okay. Okay, thank you.
Katie, you're fine. Don't feel bad at all. I appreciate the effort.
All right, David Cerna, is he in custody?
Yes, Your Honor.
All right, can you let him know that his case is going to be recalled?
Yes.
We're going to recall that one, Norma, for March 4th.
Yes, ma'am.
Mary Tedeschi, thank you for
And let him
super
know
chat.
we're just waiting for his evaluation.
I'm frustrated with that ruling, but I will get over it. I have a very short memory when it comes to things like that. I don't know how to hold a grudge, honestly. I mean, where would you pick it up by? I just, it's just not something I do. But this is a non-working super chat, says Greeners. That one, apparently, Greeners, didn't work. Thank you. I appreciate that, Greeners. Let's see, Debbie, yesterday they had the non-lawyers, two different lawyers, clients. They had different lawyers that spoke to a lawyer. It turns out that the lawyer isn't one. It's a mess. She's had some issues with that. I think that's been back
All right,
and
are the
forth a
parties
bit.
ready on Andrew Arnett?
Yes, Your Honor.
I'm loving the new fan I have.
Judge.
All right.
Speaking of new, I haven't seen that purse in the background.
All right,
there.
Mr. Arnett. Today is your plea deadline date. So what is happening?
Judge, in anticipation of today, I was reviewing discovery yesterday and noticed that there was a body cam that was missing.
Okay.
Talked to counsel about it. This morning, I have had that body cam downloaded to a portable hard drive. So I need just a little bit more time to review that before we can proceed with any type of plea or resolution to this case.
All right, I'm going to extend your plea deadline date. And Norma, is 2 weeks enough time for you, counsel?
It is, Your Honor.
All right, Norma, can you put this the week of the 20th?
The 22nd?
22nd?
That'd be ideal, yes.
All right, we'll recall you for the 22nd. And after you sign the reset form, you're excused.
Thank you.
Thank you.
Thank you, Judge.
You're welcome. Are the parties ready on Chelsea Mock?
Yes, Your Honor.
Thank you.
Steven, thanks for the disco ball distraction. And I see the Chiefs Kingdom logo.
And
I'm guessing you're a
probation.
Chiefs fan.
This is a plea. There's no application?
No, Your Honor.
No application. Court is calling 2000 and Miss Guerrero, if y'all can move down there. Court is calling 2022 CR 3724, State of Texas versus Chelsea Monk. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
John Young for the defense.
And are you Miss Monk?
Yes, ma'am.
All right, Miss Monk. I'm going to show you what's
Thank you, Jill.
entitled
Thanks for the
True
super
Bill
chat.
of Indictment. Did you review that document
Yes, ma'am.
with your attorney?
Yes, ma'am.
And did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Monk, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did
Yes,
you
ma'am.
understand it? Did you sign it?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Your Honor, in this case, she had been found incompetent in Judge Carruthers' court after an evaluation. She has been reevaluated recently and had her competency restored on Tuesday. And that is why we are here today. And I also believe she is competent.
All right, and do you believe she was sane at the time of the offense?
I do.
Ms. Spunk, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed under 1244 to 360 days in the Bear County Jail. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor, she has 438 actual days in jail.
All right, state, is that the plea?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Iris,
No
who is
objection, Your Honor.
GRAI?
All right, state, you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you
Yes,
sign it
ma'am.
at all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial?
Yes, ma'am.
A right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And review the same. While she's doing that, Attorney Shannon has a YouTube channel. I would love to see what that channel is. I didn't know she had one. I can't wait for the gag order to be over so I can apologize to her. Let's see. Who sent the letter regarding not broadcasting which trial? That's the judge of that over that case in Colorado. I need an intern. Yes, interns are about the right price. That's about my price range of what I can afford right now. Oh, sorry. You just need to say Kathy, Iris. You just need to say Kathy. Sorry.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Kathy, I apologize.
Anything you wish to say on behalf of your client?
I know you by your full channel name,
As
not by the
noted, Your Honor,
abbreviation.
my client is rather eager to get this all behind her. Her father has hired me to represent her, and I believe that the family unit will be very stable.
Father
All right,
hired
off
me.
the record for a moment. Counsel, you're blocking the deputy's line of vision.
Sorry.
All right, we're back on the record. All right. Does she have any type of mental health or treatment set up for her?
I don't believe so, Your Honor, and I'm honestly not sure what the reason for the original referral was. Since I've been hired, which was about 3 or 4 months ago, I've never seen any indication that she had any lack of competency. I believe there may have been some issue at the time of her arrest about a burglary charge that did not go forward. But I've never seen any indication that she has had a problem with competency.
All right. So, Ms. Mock,
Yes, ma'am.
you're looking healthy right now. Do you remember how you used to look?
Yes, ma'am.
All right. Can you show that to her?
Kathy, thank you very much. I'll have to watch this. You said she's got a YouTube channel.
So I don't want you to have any issues. I know that you're getting offered this offer and it's a judgment satisfied. I'm going to give that to you, but you don't want to go back to being that person. I can see you. Your eyes are bright, shiny. You're understanding and focused. If you fall off track, don't be that person where somebody's identifying a body and it's yours.
Yes, ma'am.
There are so many places where you can get help now, help for drug treatment, help if you have mental health issues, and it's all free. You just have to ask for it. So don't leave the jail and go celebrate. Don't go with your friends, people who are encouraging you to use, because you know what? Those people are not your friends.
Yes, ma'am.
So the same person who hired your attorney, your father, that's the person who cares about you. So you need to go straight knocking on their door and say, I need help. You know, can you help me get treatment? Can you help me do this? Because otherwise you're going to backslide and you may get lucky and just look like that person in that photo, or he may have to identify your body. You understand?
Yes, ma'am.
All right. So I'm going to find you guilty. sentence you to 360 days under 1244, give you credit for any time served, and I will show that the judgment is satisfied.
Thank you.
You're welcome. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And
Yes,
did
ma'am.
you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. If
All right,
something happens and you can't find a place for treatment or find mental health treatment or drug treatment, you can always come back to this court and I will give you information. We'll make sure you get the help you need.
Yes, ma'am. Thank you.
All right, good luck.
All right, thanks.
All right, who's here on Abel Rodriguez? And after Abel Rodriguez, the next person I have up is Amber Holland. And then I have Isaiah De Los Santos. So if your name has not been called from that bunch, it's because nobody has given me the file. All right, Abel Rodriguez.
Morning, Your Honor.
Good morning.
Okay.
How are you doing, counsel?
I'm good,
I
Your
heard a
Honor.
buffer
How are
sound.
you?
Hang on.
All right, that's great. I know you have been out for a while and I was saying I need to check on you.
Yeah, I'm good.
All right. Court is calling 2023 CR 4795, State of Texas versus Abel Rodriguez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Nifa Gallegos Carrillo from Mr. Rodriguez.
All right, and probation, this is person on probation. Are you Abel Rodriguez?
Yes, Your Honor.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Abel Rodriguez who was placed on deferred adjudication in 2023 CR 4795 for the offense of theft $2,500 to $30,000 vehicle on June 8, 2023 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 4 in Bear County, Texas, the defendant, Abel Rodriguez, the defendant there failed to report to the supervision officer as directed for the months of July and August 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor will waive the remaining violated conditions.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court is going to find violation of condition number 4 true. Is there a proposed agreement?
Here is, Your Honor.
Yes.
And that is to deny the motion and to amend for bi-weekly drug testing and bi-monthly office visits for 4 months. And it says 0 tolerance.
Okay. All right, Mr. Rodriguez, you want to raise your right hand for me?
This is Bayer
Do
County,
you solemnly
Texas.
swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Abel Rodriguez.
Did you
All
say
right,
yes,
Mr.
sir?
Rodriguez, why are you
You
doing
said yes,
poorly
sir.
on probation?
It was a family issue. My father was passing away and my support group was mainly in Arizona. And he sadly passed away and I came and now I turn myself home.
But how does not reporting and not showing up to probation help you?
It didn't help me at all. He even got very upset, very disappointed. So,
And do you want to go to prison?
no,
Do you want to go to the Bear County Jail and live there?
no.
All right, because if you want to be at the state jail for 2 years, we can help accomplish that for you.
No, Your Honor, that's
Can't
not-
give you a toothbrush. I know there was a previous judge, they said would give toothbrushes and hand those out. I'm not going to give you a toothbrush. Toothbrushes are expensive now anyway. So it won't, if I were to give you one, it wouldn't be an Oral-B one. It would be one from the Dollar Tree that's now $1.25. All right?
Yes, sir.
So the family you have in Arizona, who's in Arizona?
Right now, since my father is deceased, just a couple cousins and that's all.
So where's your support group?
My support group is just mainly my reservation and my mom's side of the family that was on there. And I have my children out there as well.
Okay. So do you want to remain in Bear County or is there some other place?
I'm gonna have to remain here and take care of this. I let them all know that and they're willing to move out here. make the change.
All right, why not back on the back at the reservation
There's
location?
too much emotional toll that I have out there, and I'd rather.
How about a bouquet of toothbrushes that she can give out to people?
Okay. All right. I'm going to deny the motion. Alternate amend conditions to include a MIC evaluation and probation. What are your thoughts?
Your Honor, State and I discussed a probation rights on the court summary, and I feel like that may be appropriate.
All right.
I'd like to get a tap evaluation.
All right, so we're going to do a MIC evaluation, a TAP evaluation, and probation. If he does the TAP evaluation in jail, how long will that take?
About a week and a half to search.
All right, so we're going to do the TAP evaluation in custody. All right, because if we were to do it out of custody, it's how long out of custody? All right. So MIC evaluation and TAP evaluation while in custody. Follow recommendations from TAP. And we can also do a referral to felony drug court, because I know they have a dual diagnosis program. Is there anything else you need from the court to be successful?
No, Your Honor.
All right, so you need to make sure you report. That's what you have to do. Problems happen in your life, you still have obligations.
Yes, sir.
And this is an obligation that could result in you going to the state jail facility. You understand?
Yes, Your Honor.
All right, we can go off the record. What's with the tattoo on the side of your face?
This is a Catholic cross. I was supposed to be a lot smaller, but I did it way bigger than I expected.
Well, was he doing it freehand?
Yes.
Oh,
And
see,
he had a
if he were not, don't let people do tattoos freehand unless you know their work. Because if he wasn't doing it freehand, he would have had it stenciled and you could say that's too large.
Yes.
You can still have that removed if you want. It's just going to be extra painful.
So I was looking into that.
All right. If you need anything from the court or you feel like probation is not addressing issues, you can always come back to the court. You understand?
Yes, sir.
All right. Good luck to you. Okay.
Thank you, Your Honor.
You're welcome. Antonio Randall.
Where else are you going to
Judge,
get?
I have an update.
Where else are you going to get
So,
tattoo advice?
Apparently, the only mental health prosecutor who understands how to do the paperwork is Ms. Sunkel.
Yes.
Who has the day off.
Okay.
I'm going to email, Sally said to tell you, she's going to evaluate it. She's going to look at it. There is some concern, and it has to do with case law that came out on NGRI pleas, that perhaps it might be better, and she will talk to Mr. Gearhan about it. I'm going to do an email.
NGRI is not guilty by reason of insanity.
That it might be better simply to dismiss the cases rather than do an NGRI plea. But she needs to review everything. And right now we're going to be on Judge Carruthers' docket for next Thursday to resolve these.
Okay. So that will be Thursday the 22nd.
No, ma'am, but.
Oh, sorry. I'm looking at March.
He kept saying yes, sir. He did.
Yes. So that will be Thursday the 15th. Okay. All right. I'll notate Norma on this case. They're going to be in Judge Carruthers on the 15th.
Okay, so I'm not gonna set it, I'll let further court.
Yes.
I've already told Angela, we texted, she knows.
Okay, awesome, thank you.
Just let me know if y'all need anything.
All right.
I want to make sure I didn't miss any super chats. Thank you, Jill Ballard. Is this
And
thing
can
on?
somebody see where Kathy
Greeners?
Compton
Thank you.
is?
Mary Tedeschi. Appreciate that. Ivan, congratulations on the 12 months. And the Who Took My Candy soundbite. That's a good one. It was a little quiet. I need a good, clear one. I'm not sure if I could raise the volume on that one. Cass, also 12 months. Thank you so much. Appreciate that. ICU member for 3 months. Wonderful, wonderful. It wouldn't be the same without you. Please
Denise Thomas.
continue to be here. It's wonderful with you here.
All right, State, where are we on discovery?
Should be in good order, Your Honor.
All right, and State, were you able to tender an offer?
Yes, Your Honor, we were.
All right, how old are you? 40. All right, Miss Ferguson, I need a reset date. And if you can put this.
I think Judge Boyd has a booming vase business.
At the beginning of March for a plea deadline date.
March 7th.
All right, we're going to come back on March 7th. At that time, you'll need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right, do you need some Kleenex? All right, thank you.
Thank you, Judge.
Thank you.
If the judge asks you, do you need some Kleenex? The correct answer is yes, I do.
Who's here on Vincent Moore?
I think Sarah Boone is, it's going to be, he says 9 a.m., but every case is 9 a.m. It's just like a
Is this a
group
motion to
docket.
revoke?
Whatever shows up first gets seen first.
Ask for your reconsideration regarding an occupational license.
Has he taken
Do I
parenting
have
classes?
the,
He dressed
did you
appropriately.
file another motion on it?
I think we did. I'm not certain that it's been e-filed or.
All right, if you can check in the back, I think the clerk is back there and we'll see if we have it.
Okay.
All right, thank you.
Ms. Bush? Here's your reset form.
Okay, thank you.
Amber Holland?
Yes, ma'am, Your Honor.
Yes.
Good morning,
Good
Judge.
morning.
Good to see you.
You too. This is where Cornelius Cox would say it's good to be seen.
I'm sorry, Judge.
Better
I
to
said
be seen
Cornelius
than
Cox
viewed.
would say it's good to be seen.
It is good to be seen.
Being viewed is less preferable. Viewings and all.
All right, so what are we here for on this case?
Your Honor, I believe we're here on a compliance. It looks like that back in.
All right, let me pull up the email that the probation sent me. Okay, here we are. All right, so I ordered inpatient treatment.
You did, Your Honor, and I very much want to speak to the court on that.
Mhm.
In the last 2 months, Ms. Holland has taken and passed over 20 drug tests through her probation.
Mhm.
She's taken a drug test today and passed that. She's currently attending.
You knew I was going to ask for a drug test, didn't you?
I did, Judge. And so we did that and she passed that. She's attending NA meetings twice a week right now.
Mhm.
And she has been completely drug-free for the last 7 months since she had the one dirty UA that caused the court to believe that she needed inpatient treatment. She's been calling every single day to the drug hotline since June of last year. She lives alone. She owns her own house. She's been employed at Cowboy Grading, where she's currently employed for the last 14 years. She's working 40 hours a week. She has a dog that she's had for the last 7 years.
Oh, what type of dog is that?
That's a black lab.
Okay.
And
You have an answer to all my questions. I wanted to know.
well, I know this court asked very good questions, and so I wanted to make sure that I asked her that because I thought that you might ask that actually.
But it's not a closed book exam.
Well,
That's an inside joke between us, but okay.
and I won't make any comments to that, but I do have my opinion on that.
Texas lady, thank you.
And she's in
13
complete
months.
compliance otherwise
Thank you so
with
much.
her conditions of probation. When the court ordered the inpatient or added the inpatient as a condition, on her own initiative, she went and enrolled herself in outpatient at Lifetime Recovery. And she had already started the Lifetime Recovery actually before the court ordered the inpatient. And actually 1 month after the court amended it on November the 9th of last year, she completed her Lifetime Recovery IOP program. And so we recognize the court's concerns. She remembers the talking to that this court had with other defendants that were in similar situations during her time getting up to, and I wasn't her trial counsel at the time, by the way, but in her time in this court, she recognizes the serious nature of being on probation. And she did relapse last June, but she's been drug and alcohol free since that time. And I think has demonstrated her ability to remain drug and alcohol free. And so we're asking the court
to not require her to do the inpatient.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Amber Hollins.
All right, so what treatment are you in?
At this time, I'm
Yes.
going to NA twice a week.
Okay. And so you completed the lifetime recovery
Correct.
and you're still doing the UA hotline?
Yes, ma'am. Every day I've called for it's been over a year.
Okay. So this is what the court will do then, unless there are any other questions?
No questions, Your Honor.
All right. So you're going to continue doing your NA for 2 times per week. Ms. Abrams, we're going to continue with the UA hotline, but with the UA hotline, it's only going to be testing. We're going to start out with testing once every 2 weeks, and then we'll do testing once every 3 weeks, then testing once a month. I still want the UA hotline there because it's random.
Not a problem.
So one day you may have to test, one day you may not have to test. So we're going to handle this in incremental stages until you're on for regular testing.
It's like
All right.
a lottery for drug
Do you have
tests.
any questions
what
about
she's
anything?
talking about.
Anything else for me to say?
Every day
No,
you
ma'am.
call up, and that
All right,
might be
keep
the
up
day
the
you
good
have to
work,
go
okay?
get tested.
Maybe excuse
Yes.
for this person.
Yes.
I have someone else.
It's
but-
All right.
it's more
Who's your
lenient
other
than,
person, counsel?
than testing every day. But
I'm having a senior moment, Judge. Salty Banyas, Judge.
All right, let's bring Saktabandas up
Judge,
if you're ready.
I'm not ready on that.
Okay.
Yeah. So I want to talk to the state on that because we can reach an agreement.
All right, state, Suzanne Kramer is on by Zoom. Could somebody call her?
I'm sorry, who, Judge?
Suzanne Kramer.
I have not.
I think her defendant is in federal custody.
Okay.
It is Jesus Eduardo Garza.
I'll text him real quick.
Thank you. Oh, she's on Zoom too.
Oh, okay.
Suzanne, are you there? He's on page
I think
10.
a lot of people are
Yeah.
just kicking back and listening today.
All right,
This is
Suzanne
a-
Kramer is sort of.
This is a recovery period for us.
All right, so do you know, is your client still in federal custody? The last notice we heard that he entered a plea on December 11th in his federal case.
And I believe subsequent to that point, Judge, I spoke to Paul Smith and he told me that he got 10 years. Now we would, I'm not sure. I mean, I know I talked to Paul about that, but I'm not sure if that's accurate, but I believe that he was sentenced. So I don't know, y'all can bring him back for us to take care of this and then we can send him back to federal court, but that's where we're at.
I like hearing y'alls in court.
Just from our notes on our system that I placed there back whenever, our clerk had told us that he is being sentenced in February of 2024. So it is February, but then it's noted on there that he is supposed to be transferred back to Bear County or to Bear County facilities at that point. I haven't seen him. I don't know if he's in our jail.
All right, Deputy Lord, do you know if Jesus Garza is in? All right, so what we'll do is we'll recall this, Ms. Kramer, we're going to recall this for the beginning of March before spring break.
Okay.
And so
by then.
we're going to bring him back on March. Ms. Ferguson? Yeah. On Garza, we even brought back the first week in March, the week of March 4th. All right, we're going to put him down for March 5th and we'll see if he's back from federal.
Okay, thank you so much, Judge.
Thank you.
May I be excused?
Yes.
Thank you.
No.
Who said no? I think that was a different conversation. But yeah, a lot of people are lurking, getting some work done. Appreciate you guys being with us. Thank you so much.
That's, I mean, if that's accurate.
Camilla Scalbon. Somebody just sent me a video of roaches fighting. I don't know who won.
I don't know who won.
Hello. All right. Hi.
Good morning.
Good morning. So today is the plea deadline date.
Yes, Your Honor, we are respectfully, sorry, I was. We are respectfully declining the plea at this time, and we would like to advise the court, as we have advised state, that we will file a motion to appoint accident reconstruction expert.
Okay, when is that gonna be done?
We can file that today, Your Honor.
All right, and is he appointed?
No, Your Honor, we are retained.
All right, so, and y'all are asking the court to approve that, or
We-
are y'all gonna pay for that?
No, we will be asking for minimal funds, to staff it, and we could go from there.
All
So he's
right,
paid for his
so
attorney,
Ms.
but he wants the
Ferguson,
court to pay for the.
we're gonna
accident
recall this back
reconstruction.
for the week of February 19th. And state, that's not a jury trial, that's just for the defense to file whatever motion they have and for the court to rule on that motion.
Okay, Judge, thank you.
Sure, which date?
On the 22nd, Judge.
All right, so we're gonna come back on the 22nd,
I'm sorry, what date is that?
February 22nd,
22nd.
yes.
So I'll just put it as a motion setting.
Yes. All right, is there anything else?
Not at this time, no.
Thank you for dressing appropriately for court.
Thank you, Your Honor.
All right, thank you. Have a good one.
May we
And that's a
be-
beautiful dress.
Thank you, Your Honor, appreciate it.
May I be excused?
Once you sign the reset form.
Very polite. Braxton Heaps, welcome to the gallery, my friend. I'll be watching from a text for you. You might have sent it already. Let me know. Judge Boyd reminds me of my late sister. My sister was an HR exec, so good that we all say folks would be halfway home before they realized they'd been fired.
Yeah, but there's no
With a
regular
smile on their
record.
face, pink slip in hand.
Coach,
On a case?
the guy's been in jail more than 9 days.
All right, just hand it to the clerk and then I'll look at it.
Okay.
Thank you so much.
We are ready to take a lunch break here in just a minute. We're just going to see if we get to a lull in the stream here. Jen Jam's watching, relaxing, whilst diamond painting and waiting for the dinner to cook. My daughter loves diamond painting.
Who's here on Robert Pettis?
Oh no, BG. We sang to Josh this morning. He's 22 this morning. And as a happy birthday, a deer ran into his car. Oh man, I'm sorry.
All right. And his mom was here in court, but she was talking to him in the box. But both parties, I do have an email from her.
Okay, no objection.
Okay. All right, we're going to go on the record. Court is calling 2023 CR 3275, State of Texas versus Robert Pettis. Could our parties announce for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Victor Gomez for Mr. Pettis.
And are you Mr. Pettis?
Yes, ma'am.
Going to show you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Robert Pettis who was placed on community supervision in 2023 CR 3275 for the offense of tampering with evidence on July 17, 2023 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 41, on or about the 19th day of December 2023 in Bexar County, Texas. The defendant, Roger Pettis, did then and there fail to comply with the rules and regulations of the felony drug court by failing to call the urinalysis line in violation of condition number 41.
How do you plead to that? True or not true?
True, ma'am.
And
Say.
Your Honor, we waive the other violations alleged in the motion.
Any objections?
No objection.
Did you understand by pleading true to violation? Excuse me, if you all could not talk so close to the court reporter. Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 5 years in prison and up to a $2,000 fine? Knowing that, do you still wish to plead true to violation of condition 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion and continue the defendant on probation. And we're asking that he attend the state ISF cognitive track followed by ISP supervision, which is the probation recommendation.
All right, and probation, that's what you're asking for? All right, Mr. Pettis, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. State your name for the record.
Robert Bettis.
All right, why are you not following the court's instructions and following the rules on probation?
Well, I was just real depressed about my daughters. I mean, this is the longest time I ever been without them. And
whose fault is that?
Yes, ma'am, I understand.
So you can't come to court and saying, I'm depressed about my daughters, and this is the longest time I've been without them. And the reason why you're without them is because of your own actions.
Yes, ma'am, I understand.
So that's no excuse. So why are you not doing what you need to do on probation? You want to go to prison?
No, ma'am. No, ma'am.
So why are you not doing what's being asked of you? I don't understand.
I was just real depressed and I forgot to call.
How can you forget to call and you're looking at 5 years prison?
That's a good reminder.
I try my best, Marlon, and I was just
the lawyer's like, remember how I told you how to answer this one?
I don't know. I mean,
this wasn't it.
I apologize. I know all my excuses ain't good enough. I know. No. I could do. I'm just trying to do better in my life, and I think this ISF will help me do it.
And you know felony, and you know the reason why felony drug court wouldn't accept you, right? And it's based upon some of the allegations in the motion that probation, that the state is not proceeding on. You understand that?
Yes,
so, you all are saying ISF? All right, the court will deny the motion. Alternate amend conditions to include ISF and the UA hotline until further notice. Is there anything else? All right. Is there anything else you need from the court to be successful?
No.
Your attorney is not on probation. You are. Is there anything else that you need?
I'm just planning to do better with my life and follow all the directions. I messed up. I do agree, and it's my fault.
That's
and
better.
I do accept the responsibilities, and I'm just willing to do better.
All right. Good luck to you.
All right. Thank you, Mike.
That was what they went over previously, not the. I'm sorry, I'm really depressed about my punishment. I hope he gets better. I really do. I hope.
Who's here on Dominique Nicholson?
Improve his life.
Yes. Dominique Demetrius Nicholson.
Yes. So what I understand.
Oh, where is he?
I understand he's in the hospital. He's in custody and at the hospital. That's based on information I got from the deputies.
Okay.
I have no, but I assume he would be here. He's in custody.
All right. So we will recall it.
Okay.
Thank you, Judge.
Norma, we'll recall this in a month.
Okay.
But of course, if you want it brought over sooner, we can bring it over sooner.
Okay, that sounds great.
All right. I need a 1 month reset on Nicholson.
I can do March 7th.
All right. We're going to come back on March 7th.
Thank you, Judge.
You're welcome.
Kevin, thank you. We did hear, sadly, that Paula Belmonte passed away. She was the witness in the Treehouse murder trial. Surviving victim in that incident.
Oh, so yeah, I'll be there too, but I don't have an announcement. I'm gonna be there. Okay. My question is, he's a Spanish speaker. Does he need to come on?
Okay, I think I've got a natural break here in this. So we're going to call it lunchtime here. and take a lunch break. I don't have a specific plan for after lunch. We can come back and see. I know we've got Judge Wolf was live today. He might still be going on. We could jump into the Tennessee courtroom down there. We've got a couple others that are out there, but we're going to continue throughout this week. We're going to do just some down days. Not that we're not going to follow true crime. We do that all the time, but we're just going to take a little bit of a break. The last case was a tough one, and I think it's healthy to sometimes step back a little bit. That's why we're not following the Ayden Montgomery trial. That is a very, very difficult case. Even the people who are seasoned court watchers are having a hard time with some of the facts and the evidence that's coming out in that case. So we're going to skip that one. We do anticipate that a case that we really want to watch is starting on Monday. We're going to try to make sure that all that is in place, and hopefully you guys are going to love it because it's the texting judge trial. Let's see. Did anything happen with Sarah Boone yesterday, or was it on the 9th like we all thought? I believe it's on the 9th. That's the date that the lawyer says I'm going to show up in the judge's courtroom, and as soon as he's able to see me, I'm going to ask to be released from the trial. So that's what the paperwork shows, at least. So we'll be watching for that tomorrow as well. Let's see. Is it both the texting judge and Sarah Boone in court tomorrow? I don't think texting judge is in court tomorrow. I think she starts on Monday, is my understanding. But we'll check and see if that changes. What time are we coming back? I think we do an hour lunch. Is that all right? And then we'll probably do a shorter stream this afternoon, just for a little while, and just to help you guys get through the work day for those that are watching at work. And then I've still got a few things I have to do at home. I'm done with the downstairs downstairs shower. The grouting, the ceiling, it worked perfectly. It's beautiful. I'm super happy. Unfortunately, my extra what do we call it? The fine attention to detail, the craftsmanship, the efforts that I put into that project have now inspired Mrs. R.A. to give me more projects. So my list will never end, apparently. Let's see. We do have a podcast tonight for sure. We're going to plug that again this afternoon as well. That's going to be with Weather Watch, and I need to do some work on that as well. So we're going to have a little bit of a break this afternoon to make sure I can get a couple more stories in. Let's see. I needed a court TV break to be back in the sane stream. Yep, that's what we're doing. That's what we're hanging out together. It's almost small enough. It's almost quiet enough here that we could do a roll call. I don't know. We might do one this afternoon. It depends how quiet it is. It is a very sad trial. Very sad trial. I know we've got some court watchers there. Lee and Shells, good friends of the channel who have done some court watching for us and reporting from courtrooms before, are in the courtroom, I believe, today in the Ayden Montgomery trial. So we will get some updates periodically from them. Need a new taste test on the podcast. Did you have a suggestion, Cheryl? It's a little quick for me to run out to the store and get something, but let me know if there's a product we have to try or that I need to send to Thomas for him to try. I think that's the better route to go. All right. What is the trial about with the texting judge? That is a judge that during the murder trial, sent, 600 texts back and forth between her and her bailiff. Inappropriate texts about the witnesses, about how good they looked, how sweaty they were, whether or not they believed them or they were a liar, whether she wanted to jump up and clap as soon as this one was done talking. She also has some accusations of some inappropriate. I have to be careful how I say inappropriate. Some strange pictures involving a pink chair and lawyers that she thought looked good, requiring them to be photographed in her chair. All this is going to come out. It sounds worse than it is, I think, but it's pretty bad anyway. So, anyway. Annie Marie, thank you, RA Mods. I now appreciate you even more. Annie Marie, appreciate you as well. Tonight, when you go home, please. Yes, it's Stormstrom or something. I can't remember her name. Tracy's her name. Anyway, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe till we go live again in about an hour. Let's try for... Let's see, it's almost 1:45. Yeah, it's 12:45. We'll do 1:45, so a little over an hour. Enjoy your lunch, everybody. Have a good one. Be nice to each other. We'll see you here in a little bit.